Good evening, folks. Welcome to Friday Night Fun Night, the second show of the new year. Hope everyone's enjoying their new year and got their New Year's resolutions working out for them. I tell you, I feel better this year already. How about you, Chris? How you doing over there, brother?
Still a little tired, getting caught back up into the swing of the new fiscal year. All kinds of new business rules and everything. There's still a lot of reading to do because they don't publish a lot of that stuff until after January 1. So you end up trying to cram a whole lot of information into a real short period of time.
Well, so long as you're not retired.
Exactly. I got Post-it notes everywhere. You know the drill. So it's just kind of the nature of the beast.
Mm-hmm.
But, hey, it's typical for any kind of business.
This time of year.
Yeah.
So brief announcement here for Tony Pellegrino again, going out to Virginia, going to the Capitol there on January 20th. Still looking for some sort of a venue for the 21st through 24th.
Mm-hmm.
If anyone happens to have a venue that they might be able to share there, hopefully close within the area there. What is that? Is it Richland? What is
Richmond?
Yeah. Richmond.
Yeah.
Virginia. Yeah.
Mm-hmm.
Richmond, Virginia. Yes. So, and even then, I don't even know if I could make it out there. But we were talking about doing like a little bit of a law seminar after the main rally while you got all those people already there.
Right.
Would be a great opportunity to be right there and plug E-Clause in and say, look, you guys, here, this is how our form of government works, and these are public servants, and we have the right, not only the right, but the duty to instruct our representatives
mm-hmm.
to abolish those unlawfully created statutes. And they're not even statutes, they're a congressional act. And congressional acts are not law. Congress does not have the authority to make law. I'm sorry to, that popular belief that, oh, well, Congress makes law. No, you do not.
People make law.
People make law.
Mm-hmm.
Law gets laid down prior to ordaining and establishing a constitution which institutes government.
Mm-hmm.
It's putting the cart before the horse if you seem to think that government is the one that has the authority to make law.
Right.
It's public law, which is policy.
Well, stuff.
And here's the kicker. Article 6, Clause 3. Everyone from the legislative branch, executive branch, and judicial branch shall be bound by oath or affirmation to support this Constitution.
Mm-hmm.
That's right. Only those that are bound by the Constitution are bound to what? Everything that's created by the government. If you're not bound by the Constitution, as in an elected official or appointed into a position of public trust, you're not bound by any of it. Oh, that's sovereign citizen. No, that's called constitutional republic.
That's called sovereign
works.
The context of sovereign is sovereign authority.
Right.
That's what it says
ultimately
in the book.
Where does the sovereign authority come from?
Right.
It comes from God, because the law speaks to all with one mouth. That's a maxim of law.
I think I heard that somewhere once. I don't know where, but I think I heard it.
I might have learned that one by watching you.
Ish, maybe just a little bit.
But yeah, missed the good old days of sitting around and reading Black's Law Dictionary with you on the phone, though.
Well, hey, that's the whole reading means reading thing, right?
Right. God, that was like 4.5, 5. I don't know. Maybe it was even close to 6 hours that we had spent on the phone, just sitting there perusing Black's Law Dictionary,
brainstorming. Right. Where's the book? Swallow the book.
Yep.
It's like, oh.
I've tried that osmosis thing, and sometimes I gotta wonder if it works.
I gotta. The thing that really freaks me out is how much of this was actually instinctual for me, just because it was, oh yeah, I walked into work and the only thing I hadn't done was pulled the click, clock in lever. I hadn't done that yet.
Well,
So
this goes back to what I was showing before the show there, my 10th grade report card. And actually, I misspoke there at the end. 340 words per minute with 90
ish. 94, I think you said, right?
94% comprehension. So yes, I can read fast and I can most definitely comprehend what I read. And that was in 10th grade. I don't think I quite read that fast with that kind of comprehension anymore, but you know, that was back when I was practicing reading every day.
Right. Well, as we get older, we suffer from that CRS, can't remember SMU. So,
But I tell you, I can still read fairly fast, and my comprehension is still way up there.
mm-hmm.
And if I don't, I always go look it up. Well, what the hell does this word mean?
Right.
But that's
well,
all.
I hope everybody's getting settled in, because we're going to talk about evidence tonight. One of the, I don't know about you, but another, of the, top 10 criteria of questions that I get is, I got all this evidence and, my case this and my case that. And, okay, well, what are you going to do with it? Exactly. So that's one of the reasons why we get into this tonight. How many times have we said it? What you believe is irrelevant. What you can prove is what matters. So,
who are we talking about again?
Well, the burden of proof is on the moving party. So if you're going to state a claim, right?
So wouldn't that be the one that's got the right to a cause of action?
Oh, there you go.
Ooh.
So it kind of goes into that whole thing of, somebody declared me dead. Really? Well,
that whole
right there and don't move.
that whole first fundamental principle of due process of law.
Yeah, right.
The accuser.
Right, exactly.
The corpus delicti, the body of the crime.
Right.
Not the dead body of murder. No,
right. So
that's not what that means.
According to the Declaration of Independence, those things that are declared, laid down, and ordained and established, right? The right to life is like the first one enumerated. Number one. So who the hell broke the first of all of the enumerations? It's like, so, I know the difference between a corporation and a person, for the love of God,
a corporation and a man
ish.
Well, a person is a corporation.
Well, yeah, again, now we're getting into word salad. So before we get off topic, looks like we've got pretty much everybody assembled who's going to do this huge PowerPoint tonight. You guys are going to see somebody was busy with the scanner and the books, and well, you'll get the idea as I go along here. So go ahead and get this bad boy going. Maybe, possibly, could be. There we are. And see if I can. All right. Audio still coming through okay, which is important. All right. Good deal. So here we are back in Kirk's Law Corner 2020. And of course, yours truly. This is a corporation, by the way, for anybody who is member of the bar that doesn't quite comprehend the difference between a man and a corporation. So just for the sport of it, we want to welcome you guys to, of course, Friday Night Fun Night. And to those of you who have donated, again, we always want to say thank you to you guys, because Your contributions are what make things like this possible. So we are, we think you guys are going to get a lot out of these, a lot out of this tonight. So that's why I said there's a lot to cover. And, thank you again to those of you who have sent things. My mailbox is getting fuller and fuller as the days go on. And, the good news is she has a lot of material to scan. The bad news is she has a lot of material to scan. So kind of give you the double edge on that sword. Because guess who gets to do all of this, right? So of course, we want to know what we're going to get into is the rules of evidence and the sourcing, of course, federal rules of civil and criminal procedure, right? Remember, how many times have we said it? You got to have credible sourcing, right? So again, don't forget, all through the month of January, the new fiscal year, 20% off everything in the store. New hashtag, new t-shirt, hindsight 2020. And of course, don't forget you can get your coffee mugs. This is one of my favorites over the whole Medicare for all shift made up, for lack of a better expression. More to follow on all that as we move along. But this is a corporation, right? It's a piece of paper. It doesn't have an interest, right? It has, it is a mechanism with which to do business, right? So, this is the Florida Department of State's designation of me and what I do. Okay. If that's where the Florida Department of State wants me in the capacity of loss prevention, sweet. Right? They already know the history on this stuff, right? We've been very clear about this. This goes all the way back to the first fundamental reason why Congress is even there, right? To redress grievances, specifically with monopolies. Talk about history repeating itself.
And perpetuities.
Right?
Taxes.
Right.
Connecting all commerce onto the people.
There you go.
Like a driver's license.
Exactly. Remember, rumors were planted to the effect that the T Act created an illegal monopoly. Hello.
That's
why
it's an act.
Yeah. They don't want to.
This is the reason why we changed our form of government from a monarchy to a constitutional republic.
That's right.
We got tired of people, a group or set of men with those special titles of nobility, dictating to the people what our rights are and what we can do and what we cannot do. We told them to kick rocks.
Yep. We don't have lords here. Sorry, I hate to be the bearer of bad news, but anyway, and got to remember, right? In New York, a committee of 51 dominated by merchants, those of us incorporated in law. So there's the succession of law of creation from the beginning. So the republic, right? We've established our form of government, right? Pursuant to emoluments, not entitlements. Sorry about that. To be the bearer of bad news. And of course, we added market margin and capital as we became industrialized, right? So I changed market margin and capital to black to indicate the corporation, right? The dead entity. So, all right. So we already know what you can do with your corporation. We've covered, let me go back over that, because what you can do with your corporation, you can do all kinds of stuff with that. These things become company or corporate assets, right? Land and structures, vehicles, human resources, personal credentials, books, papers, files, and research materials. And of course, capital gains, or why these things are all shown in blue. So, it's This is the succession of commerce as we do business, which is why contracts are always signed in blue ink, right? So color of law. And that word as it appears in my oath of office, I didn't put it there. Kirk didn't put it there. That came from the state. Okay. So
Yep.
that means I am recognized. Okay. All right. Good deal. We're getting there. So we're there. So we're getting there so far. So this is what this looks like, right? And in the bigger your company gets, right, you end up splitting the executive positions, right? The operations officer, which was your CEO or president, and your financial officer, which is your vice president, right? And of course, your board of directors is split to coincide with the needs of the company as the company grows. Again, so old it's new again. This what makes it Republican in character and format, right? So again, civil due process in compliance with the first up to the 13th amendments will be complied with in accordance with the rules as follows, right? Credible sources, got to have the book. In other words, you mean to tell me I actually have to read? Yep, got to read it. Oh man. So
Yes. Reading actually means reading.
here we go again. Don't you hate it when that happens?
Yep.
So, and of course, when they start that sovereign citizen malarkey, well, you say the only thing I recognize as sovereign is my authority. So I don't know who is stating that claim, but that is a disparagement or misrepresentation of the facts, right? Those are facts, not in evidence, which kind of leads into our conversation tonight.
And then what is a citizen? Well, citizen is those that are bound by the Constitution. That's law of nations.
I mean, those of us that when we're in our official capacity, we actually have a job to do. Oh,
right.
Imagine that.
In service to the people.
Right.
You give up your sovereignty when you take that position of office or employment.
Right. So again, that's one of my favorite
to receive that emolument.
Everybody asks me why I carry red and blue pens around with me. And I say, well, am I in my personal capacity? Because then that means I'm signing as the man. That's red ink. If I'm in my official capacity, then I am under contract, and that's blue ink. Right. So seems pretty simple to me.
So what?
And
what does green mean?
I like money.
That's what I always thought. Green was money.
There we go. We'll take that. So, again, you order your investigation and they say, I don't know if I can do that. Well, you most certainly can. It's right here in the book. That's page 5.
I love how they use the correct words. The right to investigate any lawful matter.
Right.
Not legal. Lawful.
There you go. There it is.
Law.
Right. So, in other words, number 10 is the implication of everything we've been saying. Anything created by the legislature must be overseen by the legislature.
That's the law of creation.
Yeah. Well, the power to oversee that comes from the people. So if Congress creates this thing called whatever the hell it's called, and it starts to act out of Republican character and form and starts to, practice foreign law, right? Guess what? That's a violation of the Foreign Emoluments Clause. Those are emoluments violations, right? So got to bring them back into the letter of the law or just shut them down. So you see what I'm saying? You got to occasionally got to smack government around a little bit, and there's a right way and a wrong way to do that. So that's what this looks like. It's in the form of a remonstrance, and this is where you order your investigation, right? So This is me in my official capacity, which is on my letterhead and why I sign it in blue ink. So, try to help you guys remember these things because these things are important as you go. And of course, the court decided they're like, hey, we want to play too. And I'm like, well, I don't want to play court. And they're like, shut up and stand over there. Like, oh, man. All right. So here's what emoluments violations look like as far as in so much as the letter of the law are concerned. Right. This SMU right here, comes from, of course, the Declaration of Independence. Right. That language and conduct of tyrants. Yeah, that's that stuff that we said we ain't putting up with this crap anymore. Who the hell do you think you are, buddy?
Right.
Right. So, yeah, you take that crap and go sell crazy someplace else. We're all stocked up here. So, so let's talk about evidence.
Put the evidence in the car.
Put the evidence in the car, Junior. So, so what is evidence? Right? Again, we're going to say we've got this thing called evidence. We got to define it, right? It's got to, it doesn't just, pop out of thin air, right? So this is something including testimony, documents, and tangible objects that tends to prove or disprove the existence of an alleged fact. Anything presented to the senses and offered to prove the existence or non-existence of a fact. There's your first primary definition of evidence. So, anything else? Let's see fact in evidence or under fact. And then, of course, number 3, the collective mass of things, right? Especially testimony and exhibits presented before a tribunal in a given dispute. Number 4, the body of law regulating the admissibility of what is offered as proof into the record of legal proceedings, which is exactly what we're going to talk about tonight. Definition 4.
Bam.
So
I like that right there at the end of number 1. The bloody glove is the key piece of evidence for the prosecution. All I thought of as soon as I saw that was O.J. Simpson.
Yep.
If the glove doesn't fit, you must acquit.
Right.
That's the Chewbacca defense.
Uh-huh.
But seriously, that's
favorites.
it right there. It's truth, facts, and evidence.
Right.
You have to have the evidence to support the truth to make it a fact.
Right. So, but this is evidence in its true definition, right? So now that we know what it is in its true form, okay, again, because a lot of people were getting into like intrinsic and extrinsic fraud. So let's look at what extrinsic evidence is. That's evidence relating to a contract, but not appearing on the face of the contract because it comes from other sources, such as statements between the parties or other circumstances surrounding the agreement. Extrinsic evidence is usually not admissible to contradict or add to the terms of an unambiguous document. So in other words, they can't say, yeah, well, we had this agreement, but we later amended the agreement verbally. Well, if it's not on paper, it doesn't exist, right? So that's the reason you amend a contract. So evidence that is
called an addendum.
Yeah, exactly. An addendum or an amendment to, or you just say we renegotiate the terms, conditions, and write a new contract, right?
True.
Depends on what all changed. So evidence that is not legitimately before the court. Okay. Well, if it's not, how many times have we said it? You've got to bring it proper before the court. Evidence that is calculated to impeach a witness's credibility, adduced by means other than cross-examination of a witness. This means may include evidence in documents and recordings and that testimony of other witnesses. Now, as I understand it, the federal rules of civil procedure, I'm not sure about the criminal, but I have heard through the grapevine that electronic evidence, such as things like screenshots and all of that BS, because of the ease of, editing that stuff now, the court is going to put less reliance on that kind of stuff. So it's going to be interesting to see what the new rules look like coming out in 2020. But that was the word through the grapevine, because a lot of times, "Well, I got screenshots. I took a screenshot." Well, one screenshot of something out of context tells a different story than the entire context. And it's like, well, wait a minute. If this is the same conversation, why am I not seeing the whole thing? Right. Hence the reason in transcripts are done a specific way in accordance with the rules to make sure that everything is true. The record is true and correct, right? Not altered in any way. So I said it's going to be interesting to see what the new rules say as far as that type of thing. Intrinsic evidence is actually much easier because it's evidence brought out by the examination of witnesses testifying or evidence existing within a writing. So intrinsic is actually much easier to prove. Extrinsic is, especially if you're getting into something that is criminal in nature, stay away from the extrinsic stuff. Try to stick more with intrinsic, right? Because, right, we've said, what you believe is irrelevant. What you can prove is what matters. So this one here, this first one, I have an issue with because it is clear and convincing. Now you're getting into sciences, because what's real science and what's junk science? I mean, even bar members are starting to acknowledge that a lot of these sciences are junk science. So, you know, this clear and convincing standard, I don't know what they're going to plan on doing with that. I wouldn't put too much stock in it, just based on what I've been hearing. Again, you know, how much truth there is in those rumors, I don't know. Computer generated evidence, we just discussed that. That I know is changing. Conclusive evidence is one of the primaries I wanted to talk about, which is evidence so strong as to overbear any other evidence to the contrary. For example, there's a dead person laying there, right? So that's an example of conclusive evidence. Or we got both signatures on the contract and the signatures have been verified, that kind of thing. So, and then evidence that is so preponderates as to oblige a fact finder to come to a certain conclusion. So again, we're talking about first definition is in the criminal context. Second one is in the civil context. So, again, now what we're talking about here, of course, remember, these are types of evidence, right? They're definitions. So
Mhm.
conflicting evidence is evidence that comes from different sources and is often irreconcilable. Conflicting evidence is how they impugn your integrity, right? They'll come up with some ambiguous something that this conflicts with what they're saying, right? And then, of course, corroborating evidence, which is just something that confirms, right, what's already or strengthens what's already in the record. Here we go here. Credibility, right? You
Mm.
hear us talk about this word a lot. Evidence that is worthy of belief, trustworthy evidence. So that's why we say cite credible sources, right? So critical evidence, evidence strong enough that its presence could tilt a juror's mind under the due process clause An indigent criminal defendant is usually. So I forgot this. Apparently, the other side of that definition didn't get scanned, so I'll have to pull that out and read it. But here's another one that I think is most important, because these two here, exculpatory and expert evidence, right? There's a lot in these two definitions alone when you're talking about types of evidence. First one being exculpatory, which is evidence tending to establish a criminal defendant's innocence, right? Prosecution has a duty to disclose exculpatory evidence in its possession or control when the evidence may be material to the outcome of the case. Remember those Brady violations, right? We watched the Twin Peaks trial and we said, yeah, had she known how to state, yeah, that's a Brady violation under the emoluments of the prosecutor's office. The case would have been over right there. So
I'm still looking for what was it? Reasonable hearsay evidence.
it's not in the book. I looked because I was gonna
Imagine that.
make sure I was gonna highlight it to make sure that it got scanned. Ain't in the book. So
Imagine that.
yeah, that's why I said SMU, right? So that's why I said expect a lot of the rules to change, but knowing this stuff as to what they've used to present against you, when you go in and say, look, even so, somebody recognized this thing as SMU because you ain't even doing it anymore. So, that's a good way to impeach their case, right? Because even that fake science or fake standard isn't even used anymore. So, this is where we get into expert evidence, right? And this goes to the fiduciary duty, right? Those credentials that, and, those of us who actually work, that's what this stuff is. This is evidence about a scientific, technical, professional, or other specialized issue given by a person qualified to testify because of familiarity with the subject or special training in the field. So, for example, Kirk and I could really give you the definitive rundown on the difference between an alternator and a generator and why those things do what they do and why they're different. The average person doesn't have that subject matter knowledge. So, hope that kind of helps you put that in context, right? In reference to what we do and how we recognize good science versus junk science. So, extrajudicial evidence, another important evidentiary standard. This actually goes back to the 18th century. This is a pretty old one. This is evidence that does not come directly under judicial cognizance, but nevertheless constitutes an intermediate link between judicial evidence and the fact requiring proof. It includes all facts that are known to the tribunal only by way of interference from some form of judicial evidence. So, short version here is we get back into that. One of the reasons they try to bring in all of these, junk scientists, right? While we watch the impeachment process, where they brought in all these liberal professors giving all these different versions of the Constitution and what the way it applies and blah blah. Made my brain hurt listening to that garbage. So, the it's like okay, did you're supposed to be in academia. How do you not know the annals of America?
Right? The history?
Right. So let's get into evidence doctrine. Right now, we're going to transition a little bit here because now we've talked about types of evidence. So now we're going to get into evidence doctrine. This gets into handling of evidence, right? So take it from the crime scene and be able to transport it from where it originated and bring it to the court or wherever it's going. This is any evidence that excludes or suppresses evidence. So any rule that excludes or suppresses evidence. Despite many exceptions, hearsay has long been inadmissible under the exclusionary rule. So one of the main reasons why you want to say, well, that's SMU, right? And context of one text message screenshot, that would fall under the first definition of the exclusionary rule. Don't you agree, Judge? So being able to articulate the doctrine, how to handle the evidence that they're attempting to use against you, right? Or objection, counsel's attempting to enter facts that are not in evidence. Criminal procedure specifically, a rule that excludes or suppresses evidence obtained in violation of an accused person's constitutional rights. In accordance with the exclusionary rule, the court did not admit the drugs into evidence because they had been obtained during a warrantless search of the defendant's home. So one of the examples when I was in college that the professor used, I remember this, is get a knock on the door to search premises for a car that had been in a car accident. Well, are you going to find a car in somebody's house? Probably not, right? Because how would you get the thing
Well,
in there? It ain't going to fit through the front door. So,
some of those cars that kind of miss the curve end up
right?
in the house.
Flip over a few
But
times.
clearly, you would be able to see that from the outside.
So, it's kind of one of those, hang on, let me open the garage door for you. Right. So,
Right.
But during the course of if the cop forces their way in, and to use the example in the definition here, would see drugs sitting on a coffee table or something, and then arrests you for the drugs, that's not part of the warrant. So that's exactly what this criminal definition means in context. So
right, because the Fourth Amendment says you have the right to be secure in your person, papers, houses, and effects.
Yeah, they had no probable cause to believe that there were drugs in the house. They had a warrant to search for a car that had been involved in a car accident. So,
Right.
Again. So anyway, that's just the way it was explained to me, and it always helped me remember it. So here's the little bit further breakdown. They always have that sub definition in the dictionary under the main one. So this is a good the sub definition here in under context of criminality is the deterrence of unreasonable searches and seizures is a major purpose of the exclusionary rule, right? It's what? To keep government in its little box. That's what it's designed to do, right? So here's a couple of cases that have been tested and some public law that goes along with it. Most recent, 1992, was that Lefebvre and Gerald Israel, Criminal Procedure, second edition, 1992. So then, of course, the original standard ones, 1960 and 1974. So, one of the reasons when they reprint the legal dictionary, other than, of course, we know trying to change the definition of the words, bastards, but the upside of this is we can get new case precedent, right? So, because again, contrary to popular belief, a lot of these judges are pretty smart. So, I mean, a judge, not these appointed fifth pillar Sharia law smews, but I digress. But an actual judge who's been doing this a while, they know SMU when they see it. So, falsus in uno doctrine, right? This is that falsus in uno, falsus in omnibus is actually the Latin. So false in one thing, false in all things. That's basically what that is from, comes from 1956. You hear me? I've actually referenced this in the negative nexus argument with reference to defective practice. In other words, they had every reason to believe this thing was Schiff made up when they brought it into court. They claim to have gone to law school and to be confident and knowledgeable on the law. How do you not know that this was Sharia law? Explain that. Well, you know, and of course they start with the circular argument, right? So you went through that, played a video on that once, as I recall. So, yep, here it is. There is an old maxim, falsus in uno, falsus in omnibus. Even in the definition, they refer to legal maxims. God, so old, it's new again. So, another one, fruit of the poisonous tree doctrine. Remember, we're talking about evidence doctrine here, right? So, the rule that evidence derived from an illegal search, arrest, or interrogation is inadmissible because the evidence, the fruit, was tainted by the illegality, the poisonous tree. So, under this doctrine, for example, a murder weapon is inadmissible if the map showing its location and used to find it was seized during an illegal search. So, you see what I'm saying? To um there's a lot of steps to go through to actually acquire evidence. So how are they going around all of this stuff is what I want to know. And oh, by the way, when they get there, what they claimed in their affidavit, which if you have to literally stand on somebody's head to get a copy of that, what they claimed in their affidavit and what the thing actually looks like is always seems to be two different things. Almost like they walked in and lied to the the court. Imagine that.
Imagine that.
So, so let's get into the actual presentation under the rules, right? So we're going to get into what this actually, you know, starting with the Article 1 branch, right? Legislative facts, right? Due process of law, Article 1. So, under judicial notice is the acceptance of a fact as true without the necessity of formal proof. So, be able to say, yep, it's raining outside. Yep, it's raining outside. That kind of thing. May be taken for the first time on appeal. So, uh, things that you don't necessarily have to, unless, of course, time's passed and you want to get a copy of the weather report. Was it raining at such and such a time? I've heard of that happening. So, legislative facts. Advisory committee's notes distinguish legislative facts from adjudicative facts. Ah, right. So we have to differentiate. What branch are you working in? So legislative facts are those relevant to legal reasoning and the lawmaking process, including statutory law and judicial decisions. So again, some of the stuff you're going to take with a grain of salt. Some of it you're going to be able to use and say, I'm going to use this to impeach my bad actors in my case, because we already know statutes, codes, rules, regulations, guidance documents, those are what? Not law.
Not law. Congressional acts are not law.
That's right. They have no standing or they are not binding on the people. How many times do the Kai courts have to tell them that? Right. So, but they're going to try to word salad and give them circular arguments. They're going to keep trying it. So, adjudicative facts. Now we're getting into some nuts and bolts here. Are the facts of the particular case. Who did what, where, when, with whom, and with what motive, right? Modus operandi. So, facts that normally would go to jury, except that judicial notice may be taken since they are not subject to reasonable dispute, as they are generally known to come from sources whose accuracy cannot be reasonably questioned. So, now we're getting into forensics, right? Nobody's above the law, nobody's above reproach. So
I thought this was self-evident stuff, common
exactly.
sense.
So somebody says, I have forensic evidence of da 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 da. I want to see the forensic report, right?
Do,
I want my own independent forensic review done.
hey,
So,
do you
and
need
this
to hit
is,
hit your thumb with a hammer in order to know that it's going to hurt?
well, and again, talk about self-evident, but this is where they get into those service agreements, right?
Right.
You have to contract with their contractor. No, you don't have standing to tell me with whom I'm going to do business. Period. That's a power you ain't got, buddy. So, um, so now we get into federal rules of evidence, or FRE for short, govern only adjudicative facts within the trial court's territorial jurisdiction. There we go. There it is right there. Territorial or locus, location. That would be the first three rules of real estate: location, location, location.
Would that be venue or territorial location?
No,
Meets
the
and bounds.
actual location, the territory, right? It
Yeah, because
doesn't say state. It
territory is
says,
land.
yeah, there you go. Doesn't say state of, it says territorial. So,
That's right.
that's why I say don't put things in there that aren't there, and don't take things out, and vice versa. So, there's mandatory judicial notice, permissive judicial notice, and effective judicial notice, right? So, without going into all three of these in context, I will just simply leave this up so you guys can screenshot this stuff. But basically, effect of judicial notice. This is really what, where the kind of the nuts and bolts are. In a civil case, this is binding on jury to accept as conclusive any fact judicially noticed. So again, who has the power to tell the jury what they have to accept or not? Right? I would call that a usurpation myself. But because the jury has the power of what? Jury nullification, right?
They're supposed to have it.
Right? So
Part of one of those political powers.
that's right. So
Administration of our government,
yeah.
as part of the function of the judicial branch,
Mm-hmm.
which is to what? Declaratory judgment, to declare the alleged law being purported, whether it's lawful or not. That's the power belonging to the people.
There you go.
And it's exercised in that particular power is exercised in the judicial branch. But see, they've taken that power away from the people,
which they cannot do.
Pulled it into themselves. It's ours. That's the power of the judicial branch.
That's that benefit of the bar card, the one we got from the Lords.
Would that be that odious, skanky claim?
There you go again. So
the shift made up that's so skanky and repugnant, it's sickening and disgusting.
Piss you off.
Because that's what odious means.
Right. So under criminal case.
I'm just quoting Chief Justice Story from right out of his own book from 1833.
There you go.
Commentaries on the Constitution by Chief Justice Story, which he was the Chief Justice of the Supreme Court of the United States of America.
Right.
So who better to talk about
Yep.
odious claims in the Constitution than that man
right.
in 1833.
Right. So when they
shit went sideways.
Right. Well, when they try to claim and exercise powers they ain't got, coming from pillars of law that don't exist in this republic, that is a usurpation. Get that shit out of here. Hell no.
Yep.
So, and again, this is where we get into in criminal cases. Jury instructed that may, but is not required to accept any fact judicially noticed as conclusive. So, again, they're trying to take away your civil power, right? So to think that they have power over the civility, the sovereign authority of the people. Wrong. So when you go in and you claim that in the legislature saying that's some odious smew there, you don't have to go in there and say I'm the living man because you just did that. It's just, that's the way it is. So just by walking in there with your remonstrance and claiming it in due process, as the example I showed on the last show, it was, oh, well, we heard you were dead. Well, I got better, you know. So anyway,
Something that I noticed there is on judicial notice is of the law of nature,
yeah,
which is natural rights
that's right.
from the Holy Bible.
You got that right. Yeah, David Eugene, you ain't the boss of me. I love that. So
Right.
now here's where we start getting into judicial rulings. Right out of the box. Erroneous only if substantial right of party is affected. See U.S. versus Olano. Wish they had a date on that one. For some reason, they didn't put the years and the dates on these, but I'm going to have to do some homework on this and try to get some of the, Brady versus Maryland. I think that was 66, 69, something like that. Or was it newer? I forget.
66.
No, that was Miranda was 66. I have to,
No,
I'll have
Brady.
to look,
I
I'll
know.
have to look up Brady again. I don't remember Brady, but some of these precedents you guys will probably recognize just right out of hearing our conversation, hence Brady or Miranda. But some of these have changed.
63, pardon me.
Was it 63? Okay.
Yep.
I'd buy that for $1.
737 US 83.
Okay.
1963.
Oh,
Landmark
again,
United States Supreme Court case
right.
established that the prosecution must turn over all evidence.
Imagine that. So,
And
well, of course, you got to
that's the problem
remember
they don't like to have, including like, oh, well, the Fourth Amendment. We violated the Fourth Amendment. We violated the Fourth Amendment, but we don't have to give that evidence over.
Yeah, sure you don't.
Yeah.
So, anyways,
How did you obtain that evidence again?
Exactly. But you got to remember these are just kind of like quick references, right? To
Right.
oh yeah, that's right. The preliminary questions, that's right. So
I still haven't seen the clean hands doctrine.
I didn't go into clean hands. That's something else. Because now you're talking about right to a cause of action. That doesn't have so much to do with evidence as it does with the right to a cause of action. Because remember, we're talking about evidence and evidence doctrine. So
right. So if it's a Brady violation, you got dirty hands.
Yeah, if they commit a Brady violation, their hands become soiled, right? And they lose they lose their standing in law. Yeah, absolutely.
Yep. Violates due process law.
That's right. But the clean hands doctrine violation occurs because of the evidence violation, right? So, order of operations. And so, as far as like the, in context here, to use the preliminary questions, for example, the court determines questions regarding the following: qualifications to be a witness, whether privilege exists, and of course, admissibility of evidence. So this gets into, remember, that can't take a right, convert it into a privilege, license it, and attach a fee to it. So does the privilege really even exist? That's a logical question, right? I would certainly want them to inquire into that. We get into these junk sciences. So somebody comes in, oh, I've got this wonderful science, da 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 da, and it should be licensed and da 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 da. Well, can I go anywhere on the globe and duplicate what it is this thing is you're saying? Because I don't care where I am on the globe. -1 times -1 is 1, period. Doesn't matter it's location or territory. So that's the difference between good science and junk science. So again, these are things that have to be weighed by the fact finder, right? So if you want them to impeach the facts, then impeach the facts, but do it correctly. or I'm sorry, the science, then impeach the science correctly. But the court should admit evidence conditionally subject to the introduction of fact to establish the relevance of the evidence, right? So again, why would the drugs be relevant to a warrant? Sir, they were searching for a wrecked car. That's not relevant to this case. That falls under the fruit of the poisonous tree, which can also do what? Violate that. What was the doctrine you just stated?
Clean hands doctrine.
That's right. So now
Don't come out off the back field there like you've been out there giving suppositories to cattle all day and walk into
right,
court. You're gonna
exactly
stink up the place.
right. So
Your
yeah,
hands are dirty. Get out of here with that crap.
that's right. Didn't matter if they had anything, viable or feasible or not, right? If it's not, if they're not going to bring it proper, and too bad, so sad, right? So, that is, yeah, you just lost all rights to a cause of action or any jurisdiction, perceived or otherwise, you thought you had. So now we're going to get into a little bit on burden of proof, right? How many times have we talked about the burden of proof being on the moving party, right?
At least once.
I would say at least once ish. So, and of course, we're watching now that Schumer, in the context of the current impeachment, to bring current events in, is trying to place the burden of proof on the president. Well, just because we can prove a negative doesn't mean that we should have to prove a negative, because that's not American jurisprudence. That's not the way our law is written, right? So this is why, right, in the political spectrum, that is a political argument, right? Who are you, Schumer, or whoever, to change jurisprudence after what, more than 200 years? No, you don't have that kind of power, buddy.
Right.
Your ego's writing a check your butt can't cash.
Bingo.
So, not to put too fine a point on that. So this is why we get into burden of proof, right? We have things like prima facie, which is a must be sufficient to enable reasonable juror to support a verdict for the party with the burden of proof, right? They have to prove beyond reasonable doubt in a criminal case. So,
it's supposed to be prima facie. It's supposed to be on its face.
Right. Exactly.
Yeah,
that's
there's a
dead person
clerical
lying
error
there.
and mistake right there. 2 + 2 = 4, not 7. That's a prima facie evidence that that's a mistake.
Right. Exactly.
Those of sound mind know that 2 + 2 = 4.
Right. So, and of course, as we just got done saying, burden is on party who asserts facts. So you're going to state a claim, you better be able to back it up with evidence. So what you believe is irrelevant. Only what you can prove is what matters. So, or disprove. They're making a claim against you. You have a contradictory piece of evidence, right? We just talked about that as one of the types of evidence. Presumptions. Now, this is where we get into rebuttal presumptions, right? Burden of going forward with the evidence on the opposing party, right? So, you're going to place a rebuttal presumption on them. Okay, well, there's criteria for that. There's the bursting bubble theory, which cracks me up. I actually laughed out loud when I read that because I had never seen that before. Even in college, I'm like, bursting bubble theory. There's something new. So, a presumption is not evidence, but rather a preliminary assumption of fact that disappears after the introduction of sufficient evidence to sustain a contrary finding, right? So, hate to burst your bubble. I just love that. That cracks me up. So, And of course, conclusive presumptions, which is rules of substantive law that cannot be rebutted by producing evidence to the contrary. So, yeah, that's a dead person laying there. Nothing you can say or do is going to say that that person can prove that that person is anything but a dead person. So it
Right.
is what it is.
Is that a fiction in the intangible, or is
Right,
that a man in the tangible?
right, right. So, and of course, burden of persuasion, right? Burden of persuasion is on the plaintiff, right? So, um, present legally sufficient evidence to persuade trier of fact on all issues. Burden on plaintiff to prove allegations in the complaint. How many times have we said this? And burden on defendant to prove all affirmative defenses. Burden does not shift, right? So when you implement that, defendant by plea or exception becomes plaintiff, right? That's a double-edged sword.
Right.
So, you have to be careful because it is easy to prove reasonable doubt. Proving guilt is not so much. So, you know, you better have some skills before you're going to go down that rabbit hole. Preponderance of the evidence. This is the civil process, right? This is a fact at issue is more probable or likely to exist than not to exist. Very simple, right? Clear and convincing evidence, and of course, beyond reasonable doubt being criminal. So, um, again, I'm not exactly sure what the clear and convincing standard is as far as a preponderance of the evidence goes, especially with so much electronic evidence being impeached right now, right? Hence the lies to the FISA court, yada, 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 yada. The fake dossier, right? Because I think this is the evidentiary standard that they're going after, but I could be wrong. It has happened. So just keep your eyes on the rules of evidence because that clear and convincing may just disappear. And we're going back to preponderance of the evidence and beyond reasonable doubt. This third SMU does not exist, right? That that came later. Yeah, that's an alteration of the fundamental law. I don't think they can do that, but I mean, just saying. Kinds of proof: direct evidence. So proves a proposition directly, goes directly to the material issue without inference. Yep. Um, got what eyewitness testimony. The issue killed the victim, right? So, or as I just got done saying, yep, that's a dead body laying there. You can't change that. Circumstantial evidence tends to prove issue indirectly through inference, evidence of collateral fact from which alone or in conjunction with other facts existence of a material or ultimate fact can be inferred. Well, now we're getting to inferences, right? Because now you're getting into assumptions. Well, again, I always remember what my grandma and grandpa used to say about assumptions, but I'll leave that to you guys in your interpretations of the word assume. Moving on. Again, relevance. There's a test for relevance, right? So, they want to bring in something that is completely irrelevant to what's being litigated properly before the court at that time, right? You say, "Hey, objection. That's not relevant to the what we're here to talk about in the here and the now. Sorry about your luck, buddy." Right? That would be a fishing expedition, right? They can't do fishing expeditions. They think they are Jacques Cousteau. So just saying. Limits on otherwise relevant evidence. Now, this is where it starts to get a little sticky. So, All relevant evidence is admissible except as excluded by some specific rule. For example, that legal doctrine we just talked about, the exclusionary rule, the falsus in uno doctrine, right? And, you know, other different forms of, doctrine directly related to evidence. So, trial judge has broad discretion to exclude relevant evidence if its probative value is substantially outweighed by danger of unfair prejudice. Boy, there's a word. There's a word. We keep hearing that a lot. Confusion of issues, misleading the jury, or undue delay. Right? Yeah, that's a penalty. I think even in football they have a penalty for delay of game. Right? So, and of course we see exclusion of evidence. Well, we saw the exclusionary rule. One of the reasons that we made sure that got scanned. Limited admissibility. This is when the evidence can be relevant to many issues. It may be admissible to one, but not another. For some reason, jury instructions tell jury for which issue evidence is admissible to disregard it as to other issues. Now, this takes me to the you can't unring a bell thing. Again, I'm just a person here, just a guy sitting here talking to you guys in the microphone. And how do you unring a bell? That's just a question I just want to. Yeah, thank you very much. I didn't think that was possible. You could unring a bell. So
I haven't figured out how to do that.
yeah, you know, yeah. Anyway, moving on. So, exclusion of evidence. The court has discretion to exclude relevant evidence when its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence, right? This is why we say right there, less can be more, right? If you have one or two documents that prove a point, why beat a dead horse? You've already done that. Move on. So, you know, keep yourself from sounding like a blubbering idiot, right? When you go in and you say, well, this allegation was made. Look, even the investigating agency says that out they found no evidence of that. Can we move on from this, please? Right? And so much for that fake allegation. Bye. So unfair surprise. This is another one. Not ground for exclusion, additional ground for exclusion in some states. So again, you're going to want to see what your rules of evidence say, because if somebody springs something on you at the last second and you're not prepared for it, hence failure to disclose, right? Well, there might not be an unfair surprise exception, but there certainly is a Brady exception, which is standard. So, again, some of these things you can impeach this stuff if you know where to find it and how, and claim full faith and credit in what would be a judicial standard of Brady, for example. So, let's see here. Abuse of discretion to admit prior judgment of conviction despite offer to stipulate, right? You say, look, we agreed to this already, right? And, in the agreement, this, whatever the thing was not going to be discussed. Well, if they violated the terms conditions of the agreement, they just lost any and all jurisdiction that they just thought they had. So, right? And that would be, remember, this is under exclusion of evidence. So when they try to come in here and do nothing but impugn your integrity, which is what we know they're doing, those privileges don't exist. That pillar of law doesn't exist in my republic, buddy. So Policy-based exclusions, privileges, hearsay, settlement negotiations, plea negotiations, and withdrawal of plea, subsequent remedial measures, and offers to pay medical expenses of injured party. So in other words, you say, hey, look, we already made the agreement. Why are they beating this dead horse? That goes into that unfair surprise, right? So trying to impugn your integrity. Court did not have jurisdiction in trademark case where covenant, basically not to sue, was unconditional or irrevocable. So this was already v. Nike. So haven't read that case yet. I'd be interested to see that case, what the argument was. So anyway, moving on. Determining relevancy. This is a big one. You say, well, attempting to introduce facts that are not in evidence. Well, you can say, objection. What's the relevancy of that? What does that have to do with the price of tea in China with what we're talking about in the context of this proceeding, right? Remember, the debate process in the legislature is exactly the same as this. So as you work through your debates with your legislators, you'll get really good at holding these debates and applying judicial standards that have already been questions that have already been decided. That's why I said, watch some of these oversight hearings as they've already proceeded, because, they're teaching you, they're trying to teach you guys how to do this if you'll just listen to the way they're doing it. So, again, there's only so much instruction, right? Communication is a two-way street. So you have to, be able to not just for them to get what you're putting down, but you have to be able to, get what they're laying down right along with it. So let's look at subsequent accidents, right? Absence of similar accidents in something that's inadmissible or admissible. So other contracts, right? So, there was already a contract there. Well, you can't write another contract if one already existed, right? Common plan or scheme. Here we go. Evidence of contracts with others is generally irrelevant, except there's always an exception. Don't you just love that? When indications of common plan or scheme in all of defendants' contracts. Could that be that fraud or bad faith? Remember page 25, section 16, right? So that would be a rule of evidence you could cite, okay, that would make that evidence admissible in your in context of your document when you put a piece of paper or whatever it is you want to put in there in your appendix. So and again, instructions on how to do that. I have yet to read a set of court rules that doesn't clearly lay out how to do a brief with appendix. So sales of similar property. Now we're getting into real property transactions. My subject matter, right? We're not too remote in time. Then admissible to prove value, evidence of unaccepted offers may be used against party as an admission, right? So trying to say, well, the guy says he says this house, this property is worth $500,000. Well, he's had multiple offers of 350,000. So he's asking an unreasonable price pursuant to the market comps, right? That's not a reasonable asking price. So you see what I'm saying? These types of arguments are had almost daily. So that's why having proper comps or comparable properties within they try to keep them within a 5-mile radius, but 10 is also acceptable. Anything outside of that, you're looking at farm property or industrial property or something specific to that market, for whatever the reason. So of course, and now we get into things like proper foundation, right? In determining relevancy, is the evidence presented in proper form, right? And has a proper foundation been laid, let's see here, with competency of witnesses, reliability of scientific test, right? So again, is the science reliable or is it junk science? Well, are we talking meets and bounds or lots and blocks? Because lots and blocks has already been discovered to be junk. That's a process that was implemented by the banksters, right? To add an extra hurdle to make the buyer of the finished product to have to take an extra step to secure interest in the property to convert from lot and block to meets and bounds. So, we got to watch for the SMU, man, because there's crazy crafty bastards. They'll pull all kinds of crazy shit on you. So, types of evidence. Character in civil cases. Anything in red, by the way, you want to pay special close attention to that. Is generally inadmissible to prove action in conformity therewith. Right. Introduce evidence that that defendant is usually a reckless driver to prove he or she was negligent on the day in question. No. Wrong answer. That would be a disparagement, right? Violation of what amendment was that? Oh, that's right, the 9th Amendment. So, I think that's one of those semi-enumerated rights in law, right? So it just it is what it is. That kind of like the motion 40, right? Kind of a catch-all for stuff that isn't in there already in the rules. Well, the 9th Amendment does that in the context of the letter of the law, right? So admissible when directly in use. So again, now we're talking about, are we in our official capacity or are we in our personal capacity? So when character is an ultimate fact in dispute, right? That has to be it right there. They have to be trying to impugn your character or your integrity for whatever the reason. Now we get into defamation, affirmative defense, negligent entrustment, right? There of course, you can get into multiple different versions of how they defame you, right? Again, for example, I wish dude would send me that paperwork from, I think it was California, where he found that the defense counsel, the public pretender, wasn't getting paid unless the people were losing these cases. I wish he'd get me that. Hint, hint. So, evidence of either reputation in the community or specific acts to show this character. Libel. There it is. Plaintiff is alleged to be a thief, so evidence that plaintiff has stolen things is admissible. Again, this is what we're talking about. This is actually repugnant in that there are multiple case precedents that already establish, even like in capital cases, evidence of a previous crime cannot be used in the current issue, right? So this is how they reduce your standing, right? Say just because you stole a pack of gum when you were a teenager, doesn't mean that you're still doing that at 30 or 40, right? So,
right.
That would be an example of, dude, come on, get your head out of your ass. Method of proving character, right? These are things that are very, very difficult. You're talking about character assassinations, which is what these, attorneys have mastered the art of, right? It is what it is. So you got to put them back in their box. Well, the best way to put them in their box is to know the tools they use of their craft. So that's one of the reasons we do this. And, getting into some of those criteria, the top three are specific acts, opinion, testimony of witnesses or of witness who knows a person, testimony of person's reputation in the community. So you hear a lot of that, I'm a good actor in the eyes of the community, blah, 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 blah. You hear that political argument a lot.
Right.
That's what it is, a political argument. So,
But there is the Maxim of Law under the rule, and it applies to the rules of evidence, and this specifically right here under specific acts. The Maxim of Law is you must have the testimony of two witnesses to the same overt act.
correct.
So when one man is not sufficient,
That's
that
right.
becomes hearsay.
That's right. Remember the whole Jesse Smollett thing? Remember that?
Mm-hmm.
If you ain't going to tell me that wasn't staged because there were two guys, right? Yeah.
What a coinkydink.
Yeah, exactly. Yeah, just saying. But and then of course, character in criminal cases, I'm going to just highlight the ones in red because those are the ones that are hence red flags to me.
Let's see.
Generally,
Here's the thing about this particular subject matter that we're discussing right now. Since when is a man's character on trial?
well, there you go.
Never.
That's right. So
these are supposed to be actions that have violated one of your rights.
Well, again,
to support the claim.
What does a person's character have to do with the inadmissibility or admissibility of evidence, right? Is it evidence is a tangible, right? We just looked at the definition of evidence. So that's why I said reading what they're currently using to try to impugn your character, this is stuff you need to know because you can say exactly what you're saying is exactly where I was getting ready to go with that. Because according to the actual dictionary definition of evidence, right, that is something that is tangible, a thing, right? Has nothing to do with character, has nothing to do with the person, right? That's a disparagement, a violation of the Ninth Amendment.
Yep.
So, and that's in the
defamation
letter of the law,
right? Which you were just reading the previous slide, defamation of character.
That's right. So, a good rebuttal to that would be, I object. Who does this person think they are that they think they have the right to impugn my character when they have no firsthand knowledge of anything? So, there's more than one way to cast doubt on the character, a counterattack, right? Counterclaim of somebody impugning your integrity. Well, who are you? I've never met you outside of this process. Who do you think you are, and what do you think you know about me personally, other than what you read on that paper? Because as far as I'm concerned, that's hearsay. If you're reading it off a piece of paper, I would call that hearsay, and I don't think anybody in this room would disagree with that. So, before you open your trap there, buddy, you better have evidence to support that claim.
That's right.
There you go.
Because you're writing that check that your ass can't cash.
Got that right. Your ego's writing a check your butt can't cash, buddy.
And one of the fundamental principles of the common law, the fundamental law, is thou shalt not bear false witness.
There you go.
That's the law, and it's codified in law as perjury. Perjury in the state of Idaho carries 1 to 14 years prison time. Well, question is why is that not being enforced?
Here's my question. There's also another complementary codified statute that goes with that they're bound to. Subordination of perjury. So
that's the second negative nexus.
There you go.
Second negative one.
There you go.
Subordination
so you swore to it, right? And you're trying to purport that as a positive? Get that crap out of here. You're a moron. And so the only person who can commit...
Isn't that a conspiracy?
Well, The only person who can commit the act of subordination would be somebody who has the power, that advantage, that emolument to do so, to use their position of advantage, right, to trespass the law. Hell no, you can't do that. Get that garbage out of here. Who do you think you are? So, and again, hence the reference between the fourth and the fifth pillar. This is a jurisdiction foreign to our form of government and unacknowledged by our Constitution. That's in the Declaration of Independence, buddy. So, generally, bad character, inadmissible to prove defendant is more likely to have committed crime. Rationale. Such evidence creates extreme prejudice. If the prosecution is permitted to show defendant is a bad person, jury may convict regardless of the defendant's guilt of a crime charged. So, again, this is what we're talking about, what the Dems are trying to do to the president, trying to constantly impugn his integrity. Constantly. Right? It's a constant attack. So that's why I say, Trump, welcome to family court, bro.
Right?
Because this is the same shift made up we've all been put through. So bless your heart, bro, for enduring it right along with us, man. So love him or hate him, he's taking these punches just the same as every one of us is. So,
Right.
Love him or hate him, you got to welcome him to the trenches, baby. So evidence of specific acts is not allowed unless character is an essential element of charge, claim, or defense. So, and of course, majority view. If witness denies knowledge of specific instance of conduct, remember, we're talking about conduct in the context of oversight, right? So always keep that word in the front of your mind. Prosecution cannot prove by extrinsic evidence, right? Remember, we said, what did I say? Stay away from extrinsic, stick with intrinsic, because it is more plausible on the plausibility scale. So, defendant does not open the door by merely taking the stand, right? So, just because you took the stand does not open the door to a fishing expedition. Sorry, prosecutor, that's outside the scope and authority of the emoluments of your office, buddy.
Well, this is why depositions are supposed to be done, so that everybody on both sides knows exactly what questions are going to be asked and what information is going to be given.
That's right.
You can't ask that question because now you didn't depose them.
Well, not only that, right? Because believe it or not, that actually is going to be covered in witnesses. Because what you just said is going to be coming up here in the in this segment on deposing witnesses. So we are going to cover that.
Imagine that.
Victim's character in a criminal case, something inadmissible in a rape case. This is called the rape shield. Evidence of sexual behavior or sexual disposition of victim is generally inadmissible, right? So when they say, oh yeah, well, she dressed like a slut, blah, 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 blah. Oh, no, bullshit. You cannot walk in there and say that. For any number of 1,000 reasons you wouldn't want to, but there are scumbag bar members that repetitively do that crap. That pisses me off. But majority of courts do not allow prosecution to introduce rebuttal evidence of defendant's reputation for violence to show defendant was the aggressor, which I think is horseshit. Because if we're talking equal justice and equal administration under the law, if you're going to make an allegation, me being able to look at that thing and say, see the scar above my eye? That didn't happen by osmosis. So,
right.
Just saying. But anyway, especially if you could prove it, right? Or if you had rebuttal presumption of, hey, wait a minute, that I would say that denies me the ability to present exculpatory evidence because I got a report from the investigating agency that says that's some shit made up.
Yeah, see, like the 3A there, when defendant claims self-defense, she may introduce evidence of victim's violent nature to
Right.
show victim was the aggressor. That's a fact of law.
Right. So that's why I said, that's why I was covering the red ones, because the red ones, I think those are red flags. At least they are to me. So again, you guys take this and use it for what,
Well,
for
yeah,
what
so that's
it is.
contradictory to A. C is contradictory to A.
Exactly. My point exactly.
So we got a conflict.
That's right. So this is what I say, in order to know what they're trying to do, right? Know what the red flags are.
Right. Gotcha.
Right. So,
Point taken.
Yeah, this is why we do this. This is the educational value, right? And my primary reason for doing this on a Friday night. So, we get into other bad acts, and this is where these things start to intertwine a little bit. Admissible to prove another element of present crime and not to show defendant had criminal propensity. Wait,
Well,
what?
I swear that the Constitution in the Bill of Rights there, it says that the defendant has the right to make his defense arguments.
Exactly.
That's a right. Whatever he wants to make as his defense to the jury,
Well,
the court cannot interfere with that.
That's right. So, that's actually in my remittance, in my remonstrance, right? Right to present, right to make reasonable defense, or to
There
present.
shall be no rule making that would abrogate that right.
That's right. So, you're going to tell
Rules
me
are
that
not
this
law.
is, to invoke their own evidentiary standard. Tell me that that's not clear and convincing. Na boo boo. -1 times -1 is +1. Eat that, punk. So
get that shit made up out of here.
there you go. That's what I'm talking about.
That's in conflict with a hierarchy, a higher law, actual law, rights as law.
Right. So again, now we get into motive, intent, mistake, identity, right? Common plan, or the MIMIC rule. Similar crimes in sexual assault cases, similar crimes in child molestation cases, similar acts in civil cases involving sexual assault or child molestation. Now, I'm sorry. How the fuck? So I'm just going to say it. Would that be construed as a civil case, civil violation? That shit is criminal in nature. I don't care who the hell you are. If you don't think that that is anything but criminal in nature, you're a dumbass.
Yeah.
You should be drug out and hung from a freaking yard arm.
Yeah.
Moving on.
Not come in and take the kids. You take and remove the criminal.
There you go.
Don't mess up the kids' daily routine of going to school and life at home and friends and all that.
I just have to woosah with shit like that, because that just sends me off the rails, man.
Since when did we punish the victim?
Right. Bastards. Well, welcome to Sharia law, fuckers. Anyway,
it's all by that evil design to destroy families.
There you go. The malicious designs of
money
men
on the
must
side,
be
because
thwarted.
if we take just the criminal, we don't really make a whole lot of money.
Yeah,
but if we
well,
take the kids, well, we make all sorts of money.
Yeah, well, that's that malicious design, that business plan. That's the reason I went through and audited their business plan and said, "Oh, hell no, you ain't altering the fundamental law. Screw you." So,
right.
So I said there was no defense against Sharia law until I said, "Bullshit, there ain't." The Declaration of Independence says I have standing in law to do that. Kick rocks, buddy.
Yeah, that's not Republican in character.
Yeah, that's conduct of a tyrant. As I said, now you're getting into the difference between the First and the Second Amendments.
It's an ideological conflict.
I'll give my
straight up from
ideological
the top
conflict.
of the law of this nation.
I'll give my ideological
The
conflict.
top of the law.
Break my 6-pillar manly firmness foot off in someone's ass. Can you tell I'm a little more than slightly miffed about this whole damn thing? But anyway,
Only a little.
here we go with that character again, right? That character assassination. Who the hell do they think they are to assassinate anybody's character? The fact that the defendant is careful or careless, drinking to prove drunk on specific occasion. Well, let's see here. Somebody has a drink with their meal. That doesn't make them a drunk. So, yeah, no, bullshit. Objection. Counsel's trying to enter facts that are not in evidence here, buddy. Nice try.
You know, the funny thing about that little tidbit there that triggers something in my mind is, you know, back in the day when I first started studying law in, 1995, the Idaho Code,
Mm-hmm.
all right, it used to say that when somebody got pulled over for drunk driving, there was like a litmus test, 3 different categories.
Right.
And all 3 of them all just involved the officer assisting them to get home.
Yeah.
To get the car home, or if they were too drunk to do that, to take him to the drunk take, but they can't hold him any longer than 24 hours. As soon as they sobered up, they were supposed to release them.
Right.
No criminal charges.
Well, this is where I get into this as being junk science.
I mean, isn't that the duty to protect and serve?
Yeah. So
not to harass and molest.
Right. So
and extort.
Well,
and
let's talk
traffic.
about let's just keep it simple here. Let's stick with what's on the screen because we're talking about habit versus character, right? So now we have a conflict here. I would call this junk science because
yes,
somebody may have a habit of smoking, but that doesn't do shit to their character. You can have a smoking habit but still be pretty damn good at your job. You could have a drinking habit and still be very good at your job. Right? So what's the correlation of one versus the other? Those things are, that's why I said, who the hell tied that together?
Hey,
how did that become a standard of evidence? So that's why I say these are things that I would attack to impeach their case. Who came up with this junk science? Right? So, as a means to impeach their BS, their junk science, you'd say, that's just where my brain goes, right? So, as far as habit versus character, which is ironically, red versus blue, hence the litmus test, which I thought actually giggled when I started to look at this because I'm like, damn, there's a lot of red and blue going around these days. Exclusion of relevance for public policy reasons. Oh boy, dude, I should let you jump in on this one because I know how much you just love the whole public policy argument. So I know you've been down through some of this stuff in recent cases, subsequent remedial measures, settlement offers, or negotiations, right? The whole Hobbs Act argument, right? So, Rule 407. Why the hell do we have 407 rules to begin with? I would call that overly burdensome, wouldn't you?
Yes.
Abusive process, right?
Talk about vagueness.
Yeah. Void for vagueness.
Void for vagueness.
Yeah. SMU, shift made up. So that's why I say,
the only true rules is the rules of the common law.
Well, again, we can look at the Mason's manual and go to the section on what does it take to construct a rule. So how do you have this freaking rule when it violates the law of its creation? You moron. So,
yep.
So that's why having the Mason's manual or Roberts or Jefferson's, whichever you have, or all three, whatever. That's why having those books as a basis to establish zero and recalibrate the scale, right? So scale's kind of out of whack when you pick the son of a bitch up and use it as a hammer. I would call it that, wouldn't you? So,
Yeah.
Again, keep in mind, Christian love and forbearance, extending good faith to your fellow man. You got to know and understand, by the time you've been through the shit show already, your character's been impugned. You get up to the higher court, and the higher court's looking at this thing going, like, I always like to use the Hardwick case, for example. What the hell kind of idiot takes 17 years to litigate the simple issue of, can we lie and present false evidence in court?
I know. Just
Right?
blows my mind.
Exactly. So don't tell me there's not abusive process going on here somewhere, right? So
That'd be malfeasance.
there you go, right? So again, once you eliminate the impossible, whatever remains, however improbable, must be the truth. So that said, this has to be a jurisdiction foreign to our form of government and unacknowledged by our Constitution. Conduct of a tyrant. You're fired. So, again, that's why I said going through the red flags, right, and their reasoning and rationale, that's why I say that I love the way that these were published, because the publisher even recognized these things as the way I see them, as red flags. So, there's more ways to exclude evidence than there is to include evidence, which is why I always say what you believe is irrelevant. What you can prove intrinsically is what matters. So stick with the tangible intrinsic, right? And leave the fluff out of it, right? So again, this is one of the reasons that, another question I get asked a lot is why did I get granted standing? Well, I possess logic. I obviously presented myself as a person who presents logic, is capable of practicing logic and reason. So, even under the circumstances, it was so crazy. I mean, it was so easy for them to grant standing. Hell, we gave each other every tool we ever needed, including the history. I said, "Oh, you need a company? I can create a corporation to do that." So, so much for that monopoly. Bye. They're out of here.
Right.
And if that's all you needed, dude, why didn't you say so? I could give you that. So,
torque off, Twinkie.
For it. I'm giving you an idea of how much I don't object to you guys doing the right thing. I'll even pay for it. Imagine that. So offers to pay medical expenses, liability insurance, I mean, et cetera, et cetera, et cetera, et cetera. Right. We walked in, hell, liability insurance. I mean, do I think insurance is a sham and a shit show? Of course I do. Doesn't mean that I didn't think that I still purchased it. Of course, I've shown the kids' medical cards, and of course the one for Christina and I, and but they always had their insurance. All this stuff was always paid for. Who the hell was this thing called government? With their Federal Reserve shift made up. Congress, you can't punt that power, right? That's dedicated to Congress. You can't punt that power somewhere else. So you need to take that shit back, right? Eliminate those emoluments, because that doesn't exist. So, because again, currency is faux money. Doesn't exist. It's shit made up.
Right.
So what does exist is weights and measures in the letter of the law. Or was that Article 1, Section 5, Clause 8 or something, I think is what it was. So
Article 1, Section 8.
Section 8, Clause 5. You're right.
5.
So, yeah. I knew there was a 5 and an 8 in there somewhere. I just had a bass backwards. My bad. More of those clerical errors and mistakes that I'm fond of admitting to.
Right? Some of that CRS creeping in.
There you go. Hey, well, hey, the big 5-0, right? Yeah,
That's right. It's all downhill now for you.
Right. I feel like I should be on the roller coaster with my hands straight up in the air. No.
Nothing behind you pushing you.
Right.
Woohoo!
So we have pleas and related statements. Now, here's where we get into these things because they start talking about these plea deals. So I'm going to cover this. Withdrawn guilty pleas, right? You go and you can say, look, you want to, I want to withdraw that, right? I was misled here. So pleas of nolo contendere, right, which is basically no contest, and offers to plead guilty or evidence of statements to prosecute in making such pleas are inadmissible in any proceeding. Wrong. Not in Congress, because that is fraud and bad faith pursuant to section 16. Remember page 25, section 16. We entered into this deal in good faith, and come to find out that wasn't the end result, right? So we know there's no statute of limitations on fraud, could never be. See U.S. versus Throckmorton. Bye. So I would say that shit made up, but their reasoning is what I think is really suspicious. To allow admission of a withdrawn plea would negate the effect of withdraw. Wait a minute, what kind of word salad shit made up is that? How does it negate the effect of the withdraw? The effect is to withdraw. Duh. So that's why I said, so yeah. These guys, they think they're so smart, but I mean, they're literally admitting this crap, which is, of course, one of the reasons why I don't mind doing this and spending my Friday nights with you guys, because I find this stuff and it's like, ooh, I got to share that. So, exceptions where another contemporaneous, I guess is how that's contemporaneous, I guess, statement in plea negotiations has been introduced. So, and again, in subsequent perjury prosecution, false statement made under oath, on record, and in presence of counsel, if waived by defendant, right? So again, what good faith do they have to even? Can they claim good faith to even ask you to waive your right? I would call that bad faith to even ask, wouldn't you?
Right. Yeah. Why would you want to get? Yeah, it is.
Is it? I mean, come on. Anybody out there want to argue that?
I mean, this doesn't. As an agent acting on behalf of a principal, you have a duty to act in the same manner as you were if you were the principal.
Right.
No man of sound mind would want to waive their rights.
That's right. Well, again, that's what I said. What I cannot do in my person, I cannot do through the agency of another. So, nolo basically mean, nolo contendere, meaning that it's Latin, means
uncontested.
no. Yeah, uncontested or no.
No, so, I do not contest.
Yeah.
No contest.
Right. See, and again, the whole thing is, how many people didn't even know they could withdraw their plea? Hell yeah, you can withdraw your plea, but you don't do that through the court. You do it through the legislature, because you're going in and saying, look, this was a sham and a shit show from the word go.
Yep.
I was told ABC was going to happen. What happened was XYZ. I want some oversight of these emoluments, because I know they ain't doing the job that is consistent with the letter of the law. Right. So, and again, taking the process, that's one of the reasons why I was like so happy to come out and finally be able to share those documents as I presented them to the appellate court, when even the appellate court after that presentation went, oh yeah, you're right, this is all moot. Yeah, screw this guy. So you're right. Take this back to Ohio and go beat the snot out of them, which is exactly what I'm doing. Evidence of victims' past sexual behavior or sexual predisposition is inadmissible in any civil or criminal proceeding. Right. So now, isn't that contradictory to what they just said a few slides ago?
Yeah, it is.
So why is it okay in a rape? Why is it not okay in a rape case, but it's okay in another civil matter?
But see, there again, it taints the case, because that's, a man's character is
Not an
not what is on trial.
It's not an evidentiary standard consistent with American jurisprudence. Period.
Bingo.
Right? That is some shit made up. So that is an ideology foreign to our form of government, a jurisdiction foreign to our form of government, not acknowledged by our Constitution. Do you think if we read through the Mason's Manual in the rules section, we could make a rule that would say we could do that?
I mean, look, the way I look at it is like, okay, yeah, I may have screwed up over here and did that once, 2, 3 times even, maybe, right? Sometimes I have to learn the hard way.
Well,
But that
sometimes you have to
doesn't mean
smash your
that
thumb with
someone
a
who's
hammer to know
alleging
that
that I
it
did
hurts.
something similar to that on a 4th separate occasion doesn't,
Right.
those 3 previous times doesn't mean that I'm guilty of it on the 4th time.
Right.
Where's the evidence to
Yeah.
support the claim that I'm guilty?
Mhm.
You can those 3 previous misdemeanors
Right.
is not evidence that to prove that I did it this time.
Right.
Now,
So, and again,
it can be used as a sentencing enhancement at
well,
after you've been found guilty.
but does one have anything to do with the other?
Not really.
There you go. It is
Except
not
for
materially relevant to the matter that is
being a
proper
habitual
before the
offender.
court. Well, and again, are we talking a danger to society? Right.
Yes.
Now we've implemented a standard, a protection.
There it
Right.
is.
So, again, that's why I said it must suck to be a judge right now. I'd be screaming. You got these dumbass lawyers coming up with all these fake emoluments, and the courts looking at their rule book going, how the hell did we get from like what 25, 30 pages of rules to rule 407, rule 412? What the hell is going on here?
Shit, we're over 700 some rules here in Idaho.
Right. So,
All are.
to bring the emoluments clause be proper before the court and say, yeah, dude, you got a busted emolument. They're like, oh my God, thank you. Somebody brought the word before the court. Oh, whew. God, that was close. So, and that's okay. I mean, hence the reason, Justice Gorsuch. Yep. We're going to follow due process pursuant to the Sixth Amendment. And it is what it is, man. Don't take my word for it. Go watch Justice Gorsuch's interview again. I mean, it is what it is. So, but taking these grievances to the legislature and impeaching these fake standards that have weaseled their way in here, right? That's the place to do that. Say, well, they came into Congress and said, we're going to do blah, 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 right? Their own rules, their own guidance documents or whatever, which is why they hide that shit, by the way, which is why it requires congressional subpoena to get it. But as you've noticed in the congressional hearings, how many times has Chaffetz and Gowdy said during the whole previous administration, we couldn't get not one freaking syllable? No matter how many freaking subpoenas Congress filed against the Obama administration and previous administrations before that.
Right.
So, again, you're not going to tell me that most of these trespasses didn't happen in the executive branch. So Congress was, at least trying to say, hey, wait a minute, we got to reel this back in here. But they weren't getting any cooperation. Well, when we walked in and did what we did, we said, hey, let's just recap. Let's go back to zero here. Right.
Right.
And, everybody kind of looked at each other and went, I don't see nothing wrong with just getting to zero. Do you? Nope. I don't see nothing wrong with that. Do you? Nope. I don't see
That's
nothing wrong with that. So,
recalibration of the scale of justice or the
right.
scale of equity, whichever one you're using there.
That's right. That's why I said time rules events,
Yep.
one of those maxims of law we talk about. So,
Yep,
and of
sure
course, we
does.
just keep getting better at this as we go. And again, one of the reasons why, hey, we say it all the time.
What's the other one that goes along with that? First in time, first in right, or something like that?
Yeah, something like that. Early bird gets the worm, squeaky wheel gets the grease.
No, it's actually a maxim of law. First in time, first in time, first in line, first in right, something like that.
Yeah, I don't remember that one.
So, again, that would be, reference to like a right to a cause of action
Yeah.
or fraud.
Yeah.
Well,
here's one
this
I
was
do
born
know.
out of fraud. First in time was fraud. So
Right.
fraud vitiates everything from its inception. So bye-bye.
Well, here's what I say. A fool's paradise is a wise man's hell. That's the way I put that, but just saying. Now we're going to get into some documents and here we go. Telephone, photographs, x-rays, and ancient documents. Ancient documents. Could that be like microfiche and, I don't even know whether those things would even work anymore.
Microfiche?
I'm sure they work, but I mean,
Yeah, we still use them down here at our courthouse.
I believe it. God. So anyway, they must be authenticated. See, now this is one of the things, like I was saying, we're getting into some of these rules that even the court has decided, you know what, we're going to change this shit. This is getting way out of hand. So,
Right.
um, hence the whole, Photoshop and all of that stuff, whoa, come on, time out. Yeah, no. Yeah, screenshots and all that. Yeah, no. No. This is why I tell people keep a log, right? Write a diary or whatever. Keep your
Yep.
handwritten notes. It's going to, it actually mentions in here with relevance to witness testimony that over time, a witness's testimony would change because of recollection of events. Basically, it being fresh in your mind close to the time of the event. So, that's why I'm saying it's one other reason cold cases are so hard to solve. But the best evidence rule, aka the original document rule. Original is required only when contents of writing are at issue.
Yep.
Copy admissible to same extent as original if no genuine issue of authenticity of original. So here's what I always tell everybody. Never give anybody your originals. How many times have you guys heard me say this? You keep your originals, you provide a copy, and you say, I'm taking my originals with me. If you have a copy machine, I will make you 10 copies if you want 10 copies. Yep. But I retain the original. This includes attorneys because they are infamous for, oh, whoops, that evidence just got lost. So now
I want to talk about B there. Copy admissible to same extent as original if no genuine issue of authenticity of original. So when you're submitting like an audio or video recording, you can do self-certification. And I hereby certify that this is an accurate, true, correct copy of the original. And if anyone would like to verify the authenticity of this copy, more than happy to sit down with you and play the original. But you're not getting. See, this is some of this. Oh, well, they're going to have to admit the phone. Like if you did a phone recording, there was a video or an audio. Oh, well, you have to admit that phone into evidence.
No.
If you want to admit that. No, I don't. And you should know better.
Yeah.
I can make a copy of what's on this phone.
Put it on a thumb drive, and you can put the thumb drive on a keychain somewhere for all I care.
Right. But if you want to challenge the validity of the video or audio recording, I'm more than happy to sit down and play the two side by side.
Yep.
But you're not getting a hold of the original.
Nope.
You're not entitled to that.
Right. So yes, Candy, the court will file a copy if you make notation in the paperwork that you are retaining the original, and it will be available for the court's usage. But you have to put that language in the document, right? So,
well, it's a certification, self-certification.
Right.
You're certifying that this is a true, correct copy of the foregoing, blah, 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 blah.
So,
it's in the rules of evidence, by the way.
Yeah. Which is one of the reasons why, when I scan documents, I scan them in full color. And, this way, what they have in the PDF matches, even by color, what's in my hand. They can, oh yeah, those two things, that's definitely a good copy of an original. So, that's why I said it's just knowing, having done a lot of this stuff and a lot of, going back to facsimiles. Remember when they used to do everything via fax machine? You get a copy of a real estate contract signed in blue ink. Well, the fax machine wouldn't do in blue ink. It would only do it in black ink when they were first new. So having fax transmissions on relocation contracts was a pain in the butt. So, it wasn't until after, the scanning technology improved that allowed us to do it in color, it became less impeachable. So hence the other problem with a lot of those fax machines, they started using that same paper that you get receipts on today, that heat paper, right?
Yeah.
And that always fades over time.
Yeah, isn't that funny?
Yeah. So I said, okay, well,
even put away somewhere, they still just fade.
Right. So that's why I always take and make a photocopy of my receipts and staple the original right to the photocopy in context. So, even because I know the thing is going to disappear, but, the fact that the original is still stapled to the copy, well, with my laser printer,
laminated.
Yeah. Well, with my laser printer, if you try to laminate a receipt, it'll turn the whole thing black. Because that laminating machine is.
Oh, that's right. Yeah.
Is a heat machine.
Heat.
So, but yeah.
Yeah.
Anyway, so that's why I say, parole evidence rule. Again, another one I kind of have an issue with. If agreement is reduced to writing, that writing is the agreement and the only evidence of it.
Yep.
So, and of course, there's 3 terms conditions of this. So, what's one thing about a contract? Contracts can be renegotiated at any reason for any time for whatever. That's kind of like one of the beautiful things about a contract. So if you don't put in an exit clause, right, or a renegotiation clause into a contract, then they're going to pull shit like this on you, right? So, or the reverse is true, right? If you want it set in stone and they put in they'll try to put in an edit clause. No, this was the agreement. Hence the whole MOA, or let's see, MOU, memorandum of understanding.
Yep.
Yeah, there's a memorandum of understanding standard, which is still good today, by the way. Still good case precedent.
Yep.
So
And then you both parties or all of the parties to the contract must agree to the changes to the contract.
right. So, in your MOU, and you want to make sure that you either have or not have a renegotiation or an exit clause, make sure you bring that up. So now we're going to get into witnesses, because witnesses, this is, again, I get a ton of questions on witnesses, and this is a big section. So hope you guys flip your page, go to the next page, because this section right here is going to make a lot of sense, I would hope, to a lot of you guys, because there's a lot to cover in here. So presumption of competency, right? We have witness must have personal knowledge. They must have that.
Yep. First-hand knowledge.
What are the exceptions? Well, there's exceptions to every rule. So the exceptions to every rule are in the federal. Judge trying a case and jurors hearing a case are incompetent to testify in that case. Right? So you can't be, you can't hold more than one position, which again is problematic for the bar in this context, because what I can't do in my person, I can't do through the agency of another. So how does this one agency known as the bar violating this standard? I have a problem with that. Or am I the only person? Just saying.
Yeah.
State infancy, dependence on capacity and intelligence of child is determined by the judge. So again, now we're getting into, trauma and victimization and, that kind of thing, because they're literally claiming that grown ass adults are infants. What standing in law do you have to even make that kind of an allegation, much less declaration? Take that crap and get out of here. So, here, Deadman Statute. I'm going to let you read that one, because I'm sure you're going to have fun with that.
But let's back up to the insane person may testify, or if he or she understands obligation to speak truthfully and has the capacity to testify accurately, defies the first word, insane. They're not of sound mind.
Right.
So they don't have the capacity to testify accurately. But anyway.
Right.
So Deadman Statutes. Very interested.
God.
Interested parties cannot testify about a transaction or communication with a dead person whose estate is a party to the suit. There is no Dead Man's Act in FRE, Federal Rules of Evidence.
Right.
But the state's Dead Man's Act will apply in federal cases where the state law provides for such rule.
Right.
Yeah. Can somebody kindly prove and provide the evidence of communication with dead people?
Oh yeah, out on YouTube. Kathy, Nicholas, we're gonna get to hearsay. Don't you worry. Hearsay is covered in this presentation, just so you guys know. So we're not to that
old
point
Erie
yet.
Railroad versus Tompkins. Federal court in diversity jurisdiction must apply state substantive law.
Imagine that.
But what is diversity of jurisdiction? You're talking about, again, citizens, whether a citizen of the state or a citizen of the federal government, not the people.
You mean in their official capacity, in a position of emolument. There you go. Because this is what it boils down to. No one's above the law. Nice try. Too bad. So sad. Kick rocks. That includes bar members. So,
and there's only, technically speaking, 3 jurisdictions: land, air, and water.
I don't know. We have space now.
Well, isn't that air?
No, we got space, man. We're gonna send these
but
suckers
isn't that
to Uranus.
Air? That's in the air.
Well, it's above the air, technically speaking.
That's outer air.
Right.
Because God created the heavens and the earth in the beginning. So there's your space, time, and
right,
matter.
right. Well, again, hence the
Three
whole
key elements.
hence the whole joke of space,
I know.
right? So my reference to, you want to play 5 pillars? Well, let's go 5 planets. That's right. That's Uranus. So
Darth Vader can play with my freaking space balls too.
got that
Maybe
right.
not.
You went over my helmet. So we got lay witnesses, expert witnesses. Got a couple different classifications of witnesses. Generally inadmissible as a lay witness. Admissible as to common sense impressions. Well, we're going to implement a common sense standard. I'll buy that for $1. So, somebody wants to go in and, make a logical statement. Okay. Yeah, right. That's fine. But, you're going to go in there and act like an idiot. So, such as appearance, state of emotion. Intoxication. Speed of vehicle. What the hell does speed of vehicle have to do with coming in on the witness stand? Moving on. Testimony helpful in resolving issues. There it is right there. Reaching resolution. Boy, amazing how we keep coming back to that word. Voice or handwriting identification and sense of recognition. So, again, one of the reasons they try to impugn your integrity or your intelligence or whatever. Let's see. It says, these guys they're not going to have a good day. So, hence we're going to retire to the nerdery with our calculators reference. So, expert witnesses are generally admissible, right? This is where you get into credentialed people that studied a specific discipline, right? And pursued higher education. So, and of course, all of these standards do apply with exception. Opinion on criminal defendant's state of mind at time of crime is inadmissible when defendant's state of mind is an element of the crime or defense. In other words, remember our example of the other night from A Few Good Men.
Oxymoron.
Yeah. Well, you can't testify as to what somebody was thinking or feeling on a specific date. How long ago?
Right.
So, I mean, at best you could say, yeah, just judging by the behavior, you could say they were not a happy camper, or the scar above my eye where the ashtray hit me. I think that's clear and convincing. But
or a father is awoken in the middle of the night and hears some scuffling noises and walks in on some man raping his daughter.
right?
He loses his shit temporarily and just literally beats the shit out of the guy to death. Well, that's not murder.
That's defense.
He's in the father's home, and he's committing a crime by raping his daughter.
Yep. I'm gonna break you in half, you son of a bitch.
I don't know about any other fathers out there, but or any other men out there that would tolerate such a thing happening directly in front of them.
Nope.
I know for a fact I would lose my shit. So.
Oh yeah, I'll be the first to admit that. So, yeah.
But that's what they call temporary, temporary insanity.
Yeah.
My mind at that, the state of mind in that instance,
temporary my ass. I'd get up in the middle in front of God and everybody and say, any one of you dumb shits that wouldn't say that you would act the same way, you shouldn't even be in this room. Take your happy ass out of here.
Yeah, who's the one of sound mind again?
There you go. That's what I'm talking about.
Hey, can you stop that, please? Hey, can you stop, please? Yeah, fuck
Go take a shower.
good old yellow pages. Let your fingers do the walking. Reach out and touch someone.
Reach your yellow pages, my ass. I'll go get my attorney, Smith, Wesson, and Mossberg.
That's why I said let your fingers do the walking.
Right. Anyway, moving on. Cross-examination. This is where it starts to get a little bit. This is where they start these assholes really get aggressive, right? And one of the main reasons why limitations on cross-examinations, you can literally smack the living crap out of a prosecutor when they start going off on a tangent, right? Again, objection. What the hell does that have to do with the price of tea in China with respect to what's proper before the court right here, right now, today? So,
Would that be Trinzi versus Pagliaro?
there it is.
Objection, Your Honor, attempting to enter facts on the record that are not in evidence. Not only that, that man over there does not have firsthand knowledge.
Right.
He's attempting to testify while not to evidence, facts and evidence, while not on the stand.
Right. So let's go into credibility, and impeachment may also be attacked on direct, excuse me, and witness may be impeached by any party under federal rules of evidence. Prior inconsistent statement, right? Their story changed. Regarding relevant issues only. No extrinsic impeachment on collateral matters, right? Again, stay away from the extrinsic, stick to the intrinsic as much as you can. Witness must first have opportunity to explain or deny extrinsic evidence of prior inconsistent statement. Bias is never collateral, period. End of discussion. Conviction of crimes involving dishonesty or false statement is permissible on direct. So if here's again what I cannot do in my person, I cannot do through the agency of another. Well, if you're going to attack somebody's dishonesty on direct, I'm going to rebut that on redirect. And I don't care who you are, because to do anything else would be denying the witness defense arguments, would it not? Just saying. Moving on. Rehabilitation. Explanation on redirect. Testimony of other witnesses as to good reputation for truth. I don't know about that one. You're talking about that branding, right? Going back to what, the 16th century? Yeah, we don't do branding here. Once you've paid your debt to society, right? Unless, of course, we're talking you are a habitual threat to society. So I said, these are things that are usually handled or should be handled in the pretrial conference. Prior consent statement to rebut charges of recently fabricated testimony. Wait a minute. What? Why do I need prior consent statement to rebut charges of recently fabricated testimony? That just made my head explode. Or am I not like the only one? Moving on. Privileges. Remember, can't take a right, turn it into a privilege, license it, and attach a fee to it. Just keep that one in the front of your mind here. Definition. State and common law principles based on societal desires to encourage particular relationships. Federal rules of evidence have no specific privilege provisions, but currently recognize attorney-client communications, spousal communications, and psychotherapist client and social worker client privilege. State law and court privileges apply in federal diversity cases. Wait a minute. Back the truck up there. Since when did this psychotherapist, because we already know psychology is not an exact science. You're going to get 2 opinions from 2 different practitioners. You'll get 10 different opinions from 10 different practitioners, and so on. Social workers, what in the absolute hell is that? I'm not even aware that that's even a, show me in the Constitution where social worker emolument is creatable. Can they even create that emolument? I don't ever remember seeing social worker or even psychotherapist as having anything to do with the establishment, support, or management of government on either in any of the articles, Article 1, Article 2, or Article 3 branch. So that had to be some shit made up in a previous administration. So now you know why Trump is having such a hell of a time cleaning this crap out. Right. So so I said, know the crap that they're using, and you'll know how to impeach it. So you go into the Mason's manual and you say, show me in the Constitution where this social worker emolument exists. Show me that. If you can't show me that, that's not Republican in character or form. Get that crap out of here.
Yep. Show me the process to bring.
There it is, right there. In law, not at law, in law, punk. So I said, put government back in the box, baby. So there must be a confidential communication or privilege to apply. Okay. So again, attorney-client, that's a customary one. Even though I have an issue with it, I have an issue with their standing in the 4th pillar. But again, moving on. But spousal communication, that has been around since before the republic was a republic. Was it not? I mean, that's, your vow to your spouse is before God, right?
Yeah.
Hence
That's
the
been
reason.
since the inception of the Bible.
Right. So,
and even before that.
Right. So, again,
that's why I
persons
say
who
marriage is a religious act. It comes
Right.
from the Bible.
Right.
It's an action.
Right. So I don't know of any person who who holds a privilege may waive. I don't know of anybody who's ever done that. But I guess they say you can do it.
Did everyone have due process of law to
well, there it is right there.
Right?
Right. So
every man, did you go to court and say you no longer have the right to practice religion and do the religious act of getting married,
right,
without the consent of the state and a license,
right,
from the state,
right?
But if we're a republic of the people, by the people, and for the people, that's seeking permission from your neighbor to get married. I don't need my neighbor's permission to get married.
Right.
Sorry, kick rocks.
Yeah. Eavesdroppers, rubberneckers, looky-loos, right?
Yep.
As long as holder of privilege was not negligent, there is no waiver. An eavesdropper cannot testify. You got your nose up somebody's ass and you shouldn't be there. No, you don't have the right to testify. Hence the whole thing of I have screenshots. So, again,
clean hands doctrine right there.
There you go, right there.
Who is it? Were you in the right place at the right time? Or were you somewhere where you shouldn't have been?
Well, and again,
got your nose up somebody's ass so far that you're not supposed to be there. That's intrusive.
Yeah. So that's kind of the difference between a kiss ass and a brown noser, depth perception. So
right.
So again, we're going to get into the types of privilege, right? It's these these bar members, they pass out these privileges and immunities, hence this social worker bullshit. As far as I'm concerned, this whole number 2 needs to go number 2. Just saying, because that shit doesn't exist in our Constitution. Get it out of here. Right? So that is socialist, hence the word, in character and form. And bullshit. Agenda my ass. Client, let's see, attorney client. Client holds privilege. The client holds the privilege. There it is right there. Right? From disclosing any confidential communications. So in other words, you hold the privilege to look at that defense, look at your counsel and say, shut your hole. So work product. This is of very specific. We've been going round and round and round about this in the private sector since as long as I can remember. Attorney has qualified privilege not subject to discovery unless good cause is shown. And there's a reason for that. The reason for that is if I'm performing the duties, fiduciary duties, to represent a client, okay, unless somebody has the ability to make me talk, I ain't saying jack shit. Forget about it.
That's
Hence
right.
my whole propensity for, you want to ask me about one of my cases. You can sit there and talk until you're blue in the face. You ain't getting a word out of me. Somebody who's my client wants to waive that privilege, then that's up to them. They want to talk about their case, they can certainly do that. I don't do that. Don't even ask, because you're not getting anything. So that would be between myself and the client, and at the client's discretion, maybe a judge, an executive, or a senator or congressman in context. And I always demand roundtable discussion, because ain't nobody going to put words in anybody's mouth. Not when I'm around. Full disclosure here, buddy. Let's bring it to the table. Right? So when it comes to work product, I am very, very, very stringent about work product. So no privilege if made in presence and hearing of third party, right? Act of a crime or fraud, dispute between attorney and client. That's actually a breach of duty. There it is. Privilege survives death of client. So, one of my clients, God forbid, kicks the bucket for whatever the reason. And then somebody says, well, now that the person's dead, no privilege exists. Well, according to the federal rules of evidence, privilege does survive the client of the death of the death of the client. So,
Well, yeah, the right to a cause of action doesn't cease to exist just because the man dies.
well,
Who
and
is
again, that now you're different.
doesn't the children follow the conditions of the father?
This is true, but the privilege of the confidential nature of the communication. So
Right.
this is what we're talking about. So, that's just like I said, I'm strict about that, to the point I'm even willing to admit I'm an asshole about it. And, if that's wrong, I don't want to be right.
Right.
That's just the way I look at it. So, there is no privilege if attorney's services were sought to aid in planning or commission of something client should have known was a crime or fraud. So again, that would be an unlawful contract. You can't write a contract that violates the law. That business is not lawful. That's not even a valid legal or lawful contract. So, as far as I'm concerned, that language is even repugnant, but for some ungodly reason, somebody felt the need to put it in there. But that's why I say, And of course, the whole social worker thing, now we're getting in. Ugh, yeah. I'm just going to say it, shit made up. And that's all I'm going to say about that. So one of the main reasons why is patenting, right? Patents are, those have an expiration date on them. So the problem with using a patent as a privilege, well, wait a minute. There's a thing called inevitable discovery. You guys may want to look up inevitable discovery. So how can somebody claim a privilege, meaning communication, knowing that once the patent expires, there's potential for that to come out? So there's no fiduciary duty there, and you can't implement one, right? Because that's what I'm talking about as far as junk science goes. So, hence one of the reasons why I use the source materials that I use in my methodology of practice the way I do it. Again, physician, medical field, constantly changing. I'm not a doctor, I'm not a nurse. So as far as that stuff goes, I'm not going to claim to have any expertise or any of that stuff beyond what's right here. So, again, this is where I would pick up the phone and call somebody who is properly credentialed in this field of study.
This would be, like the attorney-client. This is your right to privacy.
My brain goes to HIPAA. That's where my brain goes to with this, right?
Right.
So,
but it's the right to privacy is where the right.
Right.
The right to privacy is, this is you're in the private with a physician or with an attorney, which is, the agent acting on behalf of the principal,
right,
not a member of the bar.
right.
Nonetheless, this is privileged communication.
Right.
It was only meant to be beneficial to the agent.
Well, and
Right?
again,
So
I can see
the physician
the
is there
medical
to
field.
supposedly help the patient,
Right.
and the patient is divulging privileged private information so that the physician could allegedly successfully treat what it is.
Right.
But it's like, we work on cars and stuff, and it's like people come in and they'll say one thing, and it's like, what? Wait. Okay, well, I'm gonna. I go check that out, and it's like, no. There's something else going on here.
See, I have a problem with B2, right? 3B2. Patient holds privilege. Number 2, if patient incompetent or deceased, privilege may be asserted by guardian or personal representative. I would think that privilege, whether a person is competent or incompetent, that privilege should be respected if all men are created equal. Should it not?
Right. And that's the thing, is it's not a privilege, it's a right.
Thank you.
It's a
Because
right
my brain
to
goes
privacy.
to equal protections under the law.
Yes. But see, this is where they're trying to convert the right into a privilege.
Right. You see what I'm saying? And reduce a person's standing who doesn't have the capability for whatever the reason to defend themselves. And
when you're talking about a guardian or a personal representative, they can only act in the same manner as the principal.
Right. So, I mean, there'd have to be some pretty freaking compelling circumstances to change my mind on something like that. That's why I said, I in a situation like that, I would not want to be a judge. Honest to God, I wouldn't want to be a judge. So, I do hold a lot of respect for those who do the job and do it the right way. Again, one of the reasons why I was granted standing, because I was very clear about that. I'm going to respect you and you're going to respect me. This is not a relationship that I ever wanted. This was not a job that I ever wanted, but here's how I do it in the private sector. You do with it as you deem justified and appropriate, pursuant to the emoluments of your office. And it was just speaking the word. Yeah, speak the law. in the context of the language of the law. Again, so old it's new again. You know, again, it was one of those things. Well, you know, we're going to have to, it's not that we don't want to help you, but we have some things we need to fix over here first. Okay, go do your work. Guess what they're doing? They're doing that work. So when Gorsuch comes out and says, we're ready to start implementing protections and due process under the Sixth Amendment, that's a hint and a half that we're ready to go. 2020 is the year we're going to be doing due process pursuant to the letter of the law as far as the republic is concerned for any and all who want to claim and exercise it. So as far as I'm concerned, I'm ready to rock and roll. So, moving on. So we get into no privilege. Again, criminal proceedings. I'd have to see the nature of the crime. There's a maxim of law that states, right? The act determines the nature of the crime. So,
Yep.
Are we talking a capital offense? Or are we talking a misdemeanor? So, are we talking with intent, or intent was not proved or proven? So, clergy and accountant privileges. Well, again, because clergy, that being the whole religious thing, and I'm not going to get into all that whole philosophical debate, but the accountants and the numbers, I can tell you right now, that is the stuff where yours truly spent his career in the numbers, baby. It's all about the code. It's all about the numbers, the language in the code. So, husband and wife, as far as I'm concerned, there it is right there. Number, section B, small Roman numeral 1. Both spouses barred from testifying against each other in civil or criminal cases during marriage. As far as I'm concerned, just because we're not married anymore doesn't mean that I'm going to break that oath, because that oath that I made had nothing to do with the establishment, support, or management of the government. Don't ask, ain't going to happen. So if she would want to she'll break that oath. That's for her to discuss with her maker when that time comes. But, again, you want to jump off a bridge, I'm not going to hold your hand on the way down. I can tell you that. So to say privilege exists only during marriage, ends on divorce, I'll argue that. So you want to argue that with me? I'll argue that all day long. I got time. Civil cases and criminal cases. Federal courts see privilege as belonging to witness spouse who cannot be compelled to testify or is barred from testifying. So, it has been tested to a limited degree anyway. So, let's see. Extends beyond marriage, i.e., divorce does not terminate, but marital relationship must exist when communication is made. Okay. So, again, are we talking betrayal? Right. So I said, these are just fundamental principles to me. You guys make your own judgments. It's up to you. Leading questions. Cross-examination cannot refuse to answer. I beg to differ. Can always plead the fifth. Direct examination, generally not allowed except to establish preliminary facts, to aid witness with memory loss, when questioning hostile witnesses, child witness, or timid witness, and to develop testimony as necessary. Well, and again, now we're getting into what constitutes a hostile witness. Well, somebody not answering the question in the way you want it answered, that doesn't necessarily constitute a hostile witness. Too bad, so sad. Nice try. The ham sandwich strikes back. So, written memoranda. Let's see here. The purpose, right? To promote credibility and memory, present recollection refreshed. And of course, we get into the exceptions and what those exceptions are and the criteria. So personal knowledge, made by or adopted, and of course, timely. Timely is always an issue, right? Was that argument made timely? Was the presentation made timely? Right? Was the um, the recollection still fresh in somebody's mind? That kind of thing. So, and of course, is the writing accurate, or is the witness has insufficient recollection? Right? Well, yeah, I was there, but I wasn't looking in that direction at the time of whatever happened. So now we're going to get into hearsay. The rule. Statement made out of court by declarant to prove truth of matter asserted is inadmissible. Say that again. Statement made out of court by declarant to prove truth of a matter asserted is inadmissible. So, go out there and yell on social media all you want. Just because you say it doesn't mean it's true. You got to prove it. Burden of proof is on the moving party. Period. Policy reasons. You want to go into policy reasons?
All right. So policy. Federal Rules of Evidence define hearsay as a statement declarant does not make while testifying at a current trial that is being offered in evidence to prove the truth of the matter asserted. Rule 801. Imagine that. It kind of coincides with our Idaho rules of procedure or rules of evidence. If a statement is hearsay and no exception to rules applies, the evidence must be excluded. Yeah, so that reasonable hearsay is still doesn't apply. But anyway, adverse party denied opportunity to cross-examine, thereby denying constitutional confrontation, your right to face your accuser, and due process rights. Confrontation clause rights violated when evidence includes out-of-court statements by an alleged accomplice unavailable to testify. That's right. Oh, well, so-and-so said over there, but they're not available here to get on the stand and testify to that or be cross-examined. Now, we see this in CPS cases all the time. No man gets up on the stand to testify about the facts of why they took the children. Well, the social worker writes their report. I don't give a rat's ass who that social worker is.
Junk science.
Bingo. Jurors cannot evaluate statement to determine reliability, therefore prejudicial.
Prejudicial.
Prejudicial. Where's the rest of that?
And that's it. So it goes directly into this. So,
okay.
Yeah. So now you're getting into definition of a statement. And what you were just talking about, the reasonable hearsay shit made up. Again, it's going to start getting into where that substandard, I call it a substandard burden of proof. I don't know what else to call it. You guys make your own judgment on that one. But I call that, literally returning back to, the, hanging somebody for hearsay evidence, which has not been a standard in since I would say the late 16th century, late 15th century, earlier 16th century. So hell, it was abolished back then. So they doing bringing that shit back.
Right.
So, and who had standing to alter the fundamental law? I hate to sound like a broken record, but I mean, let's just call this spade a spade. Right? Who the hell had who has the capacity to say that policy outside of a corporate entity has anything to do with anybody other than anybody who's on the clock getting paid to do that specific job?
Right.
Period. That's limitations on policy. End of discussion. So, traditional common law view, although the declarant did not intend as an assertion, it is being offered as an assertion and is therefore just as objectionable as an assertion. What the hell is that? That's why I said this hearsay bullshit. I'm sorry. This is one of the main reasons why I just say, like, wait a minute, what? Take your hearsay and get the hell out of here. So, and I think that's why I said a lot of judges are like, they're ready. They're with us on this. They're like, we got to get this crap out of here.
That's when they go, objection, hearsay, done.
Yeah. Sustained.
Next.
Yeah. Your Honor, move on. Damn it, counselor. I'm going to hold you in contempt. I'd love to. I'd pay money to see that.
Only in the movies, right?
Right. Well, yeah. So I guess you could say I have paid money to see it.
But in real time.
Oh, God. Well, for purposes of a statement offered, for a statement offered for the purpose other than to prove truth of the matter, imagine how we just keep getting back to the truth of the matter. There is no need to cross-examine declarant, and statement is not hearsay. So, in other words, you gave this deposition that was supported by these pictures. Is that true? Yep. Don't need to cross-examine that. That'd be a waste of the court's time. So, because no matter how many times you ask that question on redirect, the answer is never going to change. It is what it is. So, although legal operative facts, legal significance to certain words offered as proof of whether statement was made is not hearsay, includes evidence of words of slander or libel in defamation action. This is all getting ready to change because of the nature of society. And, you're talking about damaging a person's reputation, difference between slander or libel, right? And one of the main reasons why I think the federal courts, the high courts, are coming out and saying, you know what? Social media is just that. It's entertainment. You can't take what somebody says on social media to heart. It's social media. If you can't take it, shut the shit off.
I was going to say, think about it this way. What happened before the internet?
Right.
Okay. So internet is not a necessity, although to a certain extent for certain businesses and that types of thing, I guess it could be. But in real time, real life, the internet is not a necessity.
Right.
It does not give you life, right? It's not food, it's not water, and it's not shelter. Those are the necessities of life.
Right.
So that's a entertainment. It's a privilege.
Mm-hmm.
It's for entertainment purposes only. It's not reality.
That's right. In spite of somebody calling it reality TV. Sorry, hate to be the bearer of bad news. So, oh, wait a minute. My bad.
Well, they're filming reality, though.
Well, and again, how much of that is semi-scripted?
Right.
So, like a little kid, you get them in front of the camera and they go nuts.
But I mean, what they're filming is actually really happening, whether it's played out, scripted, or not.
Right. Yeah.
That's in reality right
Yeah.
there.
Hence the whole word salad. So,
Right.
so anyway, offered as circumstantial evidence of the declarant's state of mind. Right. So admissible, non-hearsay because statement is not offered to prove the truth of the matter asserted, but rather that declarant believed them to be true. So yeah, you're going to make a statement and you believe it to be true, but still, if you don't have any evidence to support your claim, we're not going to admit it. I mean, that's what I said. This is what I say. These substandard burdens of reasonable hearsay. I mean, first time I heard you say that, I almost fell over. I'm like, what the hell are you talking about? So reasonable hearsay. Okay. Let's see. Offered to show time or place, right? Again, the statement is made, is admissible. So again, is that technically speaking hearsay? No, I would call that direct evidence, but some courts classify it as hearsay, which I don't know why, but they do. So statements that are not hearsay. And again, the one in red, I have issue with it, but again, you guys make your own determinations. So statements that are not hearsay are basically kind of classified. What is that, under 801D? So DA1, sorry, 801D1A, 1B, 1C, and so on and so on. So, you know, if you want to go verify some of the stuff in the federal rules, by all means do that. These are just kind of at a glance, right? In context of, oh yeah, that's right. Okay. As sort of a general rule of what's going on out there right now. So, you know, you're going to try to make heads or tails of what the hell just happened to you, having these tools in front of you to say, this is the stuff that they're using. Well, doesn't make it right, but it sure as hell explains a lot. So, again, you want to argue something as what you believe to be substandard and why. Reasonable hearsay, right? Clear and convincing. No, bullshit. We have preponderance of the evidence and beyond reasonable doubt. Anything else is smew, right? So the
there's only two standards.
Yeah, it's only supposed to be
unanimous consent and 3/4 consent.
Right.
That's it.
Yeah. So again, where declarant must be unavailable, right? There are exceptions to every rule. Trustworthiness, necessity, and of course, what the exceptions, former testimony. You know, again, somebody's story is going to constantly change. You know, that happens a lot, especially on social media. That happens a lot. I don't know if you've noticed it, but I sure as hell have. So there's, you know, stories just change and change and change. And it's like, well, it's not the way I remember the story the last time we had this conversation. But, and again, you've got exempt due to privilege, right? So if there is a privilege that exists, somebody refuses to testify, Fifth Amendment, you know, for that would be a reason you'd be unavailable. So that's why I said, you know, there's exceptions to the rule, but, you know, again, if you wish to assert your right, the burden of proof is on the moving party. So, you know, don't make their job easy. It's not your job to convict yourself. So, in a civil action, a predecessor with similar interest had an opportunity to cross-examine, or former action involved same subject matter. So, you kind of getting into a little bit of res judicata right there, aren't you?
Mm-hmm.
So, again, these are dying declarations. Again, we get into a lot of this stuff with death estates. That's why a lot of these things require an abstract of title, especially where a death has occurred. So, or if their death is impending, right? You hear a lot of what's called a deathbed confession, right? I have a feeling that we're going to start seeing a lot of those. Just saying.
Just saying.
Yeah. Statements against interest, right? So statements of personal or family history. Now, I think that somebody invading another person's family, no matter how well you know them, that's not somebody I would be bringing in. I would keep within my circle for a very long time, because I'm just saying. So take that for what it's worth. Again, another red flag. Statements that subject declarant to criminal liability and are offered to exculpate defendant are inadmissible unless corroborating circumstances clearly indicate the trustworthiness of the statement in order to prevent people confessing to other off the hook. I'm sorry, confessing to get others off the hook. So, because it's not like we've never seen that before. Hey, I'll provide your family, somebody with lots of money says, hey, I'll provide for your family if you go take 5 years jail time for me. Right? Yeah. Well, somebody who's in a desperate situation, that might seem like a pretty enticing offer. Right. But that's taking advantage of somebody, as far as I'm concerned. And that in itself would be a separate crime. But that's just me.
Right.
Let's see. Where declarant need not be unavailable because guarantees of trustworthiness are inherent. Present sense impression. Now, again, this is one of the reasons why this goes to sourcing. One of the reasons why I wanted to get into a little bit of this is because how many times have we said, right? Be careful about the sources you cite, which is why I try to stick to as much of the legal dictionary, the court rules, and of course the Mason's Manual as I can. Legal doctrine does come into play only when it's applicable. But if I can't find it in the dictionary, the rules of the court, or the Mason's Manual, or obviously the letter of the law, duh, I'm not going there, because those things are, if you can't prove it with established science, then chances are it doesn't exist. It's part of the problem and definitely not part of the solution. So, again, that kind of would get into contributory negligence as far as I'm concerned. But excited utterance, statement made out of about a startling event while under the stress of excitement is admissible. I don't know if I would do that. I don't know. I'd argue that because duress is an affirmative defense, right? I mean, so if duress is an affirmative defense, that's actually kind of repugnant, or that makes that statement repugnant, does it not? So that's why I said, some of these things, you take this. That's why I keep putting those. Matter of fact, they're in here again. I put that slide in here, your affirmative defenses, because knowing what they're using and using the affirmative defenses to countermand this hearsay shit made up, that's the best way to go about doing it, because that's something you get right from the court rules, right? Use their own shit against them. So then existing mental, emotional, or physical condition, still duress. No matter how you slice it, it's still duress. So past condition, generally excluded, no way to check memory of declarant by cross-examination, and greater likelihood of falsification. So, that would be one of those that I might kind of go either way on, depending on the context. So again, I'm going to kind of speed through some of the rest of these, because I know you guys will probably read a lot of this stuff later on as it becomes relevant to your case when you start to see these things in the bigger pictures. So statement for purpose of medical diagnosis or treatment. Now, anybody in the medical field, I would lean on somebody again in that field, and my gut goes right to HIPAA, right to privacy, privileged communication, that kind of thing. So, recorded recollection. This is where we're going to start getting into a lot of these, the validity of some of this digital evidence, because it's like, well, digital evidence can be altered easily, might I add. Digital evidence can be altered. So, handwritten notes whenever you can. Wink, wink, nudge, nudge. So, so to recap just a few of these important points, your standing, your affirmative defenses, where they come from, court rules, legal dictionaries, right? Performance is a relevant question. So if you're going to take the time to learn stuff like this, you would expect your person that you're paying to do this job to know this stuff, right? Kind of a check and a balance to the best defense against a defective brake job is to know how to do it yourself. That's what the old man always said. So,
Spoken like a true gearhead.
There you go. Who can or cannot participate in why in a quorum, right? And I can tell you right now, if the rules of the quorum, they're probably going to be pretty consistent with the court. So, I've also found a lot of that. So, Federal Rule 28C, with respect to anybody who has a financial interest or other equitable interest in a case, is automatically excluded, or should be automatically excluded. Well, that pretty much shuts down every fucking entitlement program, doesn't it?
Mm-hmm.
So, again, citing your credible sources, the letter of the law, right? So you want to attack something like a bill of attainder? You go to the legislature and say, hey, the letter of the law says you can't do this. What jackwagon came up with that stupid idea? That's repugnant to the law. Get that out of here. Legal dictionaries, right? Credible sourcing, the utmost importance. If I've said it once, I've said it 1,000 times, and I'm going to keep saying it. Right? Make sure you have your book. I'm going to check as soon as we get off the air tonight, by the way, see if the Mason's Manual did get published yet, because I would imagine the site probably updated itself by now if they were going to release it today. It's almost midnight anyway, so I know we ran way over, but this was a very long presentation. So I said, I got to get on her about
three hours,
shortening these suckers down a little bit for us. But evidence was a pretty big one, because I don't know about you, but I get a lot of questions on evidence presentation, and
right.
What can be excluded and why, and how are they getting away with this crap and why, and going to run down the list here of your affirmative defenses. These are the affirmative ones, right? So accord, satisfaction, arbitration and award, assumption of risk, contributory negligence, duress, right? Estoppel, failure of consideration. That could also be denial of exculpatory evidence. Fraud or bad faith, page 25, section 16. Illegality of any kind, for example, the contract isn't a lawful contract for whatever the reason. That could even be an injury by fellow servant, because if somebody signed off on and said it was okay to do that, that would be an injury by fellow servant for those of you in position of emolument like myself. Latches, licenses, licensing, payment, release, res judicata, statute of fraud, statute of limitations, and waiver. So I'm expecting a lot of bar members to be handing over those bar cards to duplicate what the hell it is we're doing, because being able to claim that injury by fellow servant, that would be something that they've never been able to do in history, because they're in the fourth pillar. So incorporate into the first pillar. See how easy that is?
Yeah.
You want those protections? Dude, hey, come on over. That's why I would say, come on over. You don't know the power of the dark side.
Well, this would be the power of the light side.
There you go. Well, that's why I said everything's upside down anyway right now, right? So
Right.
avoid traps like these, right? Don't do this. Good rule of thumb. If it sounds wacky in any way to you, don't do it. Just moving on. So most importantly, above all, tell the damn truth, please. I mean, if you lie, it's going to come back and get you every single time. I have yet, in all of my years of doing this, to not catch somebody in a lie. I'll get them every time. So thank you all for joining us. I think that is so cool. She did a really cool job with that. I love that. New 2020 Kirk's Law Corner with the K, the whole thing. That's awesome. This was cool too. I like how she did that.
Yeah, that's good stuff, man.
And again, for those of you who do contribute to us, we definitely appreciate that. It helps it keeps us going. It helps us gather this information for you, put these presentations together, which of course, like I said, we don't mind doing. Friday night, I could have been sitting there, kicked back, watching the boob tube, doing whatever, but I'd rather hang out with you guys and pass along knowledge. So, don't mind returning the favor. Multiple ways to reach out to us to do that, and we do appreciate it, and it does go to the intended purpose, as you guys I'm sure are well knowing now. Also, you like a souvenir option, we got that covered. Hindsight 2020 new hashtag. So put the LP on the front and the new hashtag on the back. I thought it was pretty cool. That's not even mine, by the way. That one of the guys in the shop came up with that. So
right on.
So there's your Medicare for all. God. Oh, makes my brain hurt,
Right.
So anyway, again, hope you guys enjoyed that. Sorry it took so long to jump through all the hoops on that one, but as you can tell, that was a lot of information. I thought it was important to go through it and kind of cover some of that stuff in context, just based on the emails that I get. And you guys are absolutely starting to grasp this stuff. I'm starting to notice it in your correspondence as you go down through. So the fact that you guys are getting this to the levels that you are, awesome. So I do go down through and, check the comments, and, I look for the, some of the stuff that maybe I think, you guys say, hey, could you go over this or re-review that or whatever. I'll try to incorporate some of that stuff as I go through the comments when she sends me one. I'll usually put it at either the beginning or the end. And, so I'm doing my best to try to keep up with that as best I can, knowing, of course, that, how crazy things have been. I've been kind of leaning real heavy on her to, keep us going with this stuff. So bless her heart for that. And, I think that pretty much does it for this week, at least for me.
Right.
And I hope you guys benefited from that as intended, because that was the intended purpose. And again, I want to say thank you to the judges who have worked with us in the past and helped us bring you this stuff. That'd be Judge Cohen, Judge Sam Sparks out of Texas, Judges Newfer and First out of Utah. So again, this project wasn't easy. They did take a considerable risk, right? Stepping outside the norms of what they do to say, hey, let's try this fiduciary thing out, right? What's the worst that could happen? We'd sanction the guy. Well, hey, gave him real law, real research, real history. We found out that it was a good relationship, a good quid pro quo, and a good reciprocity was established there. So, again, that's why I always say thank you to them, because they didn't have to do what they did for us, but they did it anyway. Under circumstances when the country was at its worst, they stepped up. So again, I always want to express my gratitude. And on that note, I guess we'll see you guys Monday for Monday Night Law.
Yep. Have a wonderful weekend, all. Thank you all for tuning in. Like, follow, and share there on Facebook, and get subscribed over here on YouTube. Hit the thumbs up and share. Get this knowledge is power out there.
Mm-hmm.
Knowledge is power. So got to have the knowledge to have the power.
You betcha.
We're trying to teach you what to do with that power once you have it.
Mm-hmm. And what not to do. Right.
Yeah. Right.
So,
some of the errors that we've gone through, right?
I thought I was wrong once, but I was mistaken.
All right. Well, much love to all of y'all out there. And again, thanks for tuning in. Thanks for the likes, the follows, the shares, and the donations. I greatly appreciate it. Helps keep the bills being paid here.
Mm-hmm.
So we can continue doing this.
Yep.
So much love to everybody out there, and have a wonderful weekend. And we will see you on Monday Night Law.
You betcha.